We're ready to go.
We are streaming,
Oh, it's do you somebody there?
but you see more.
Mine is mute.
Stop live. Now, once you started.
Carlo knows.
We're live.
Do I start?
Yes,
Recording, this is the New York City Board of
You just hit pause.
Appeals. Wait,
is your microphone on?
Tony, could you please start again? Her microphone is on. I can hear her.
this one also. Oh, yes, I just.
So from here on until the end of the day.
Yeah.
We cannot hear anything. I cannot hear anything.
Good morning, this is the New York City. See when I.
Okay, now,
Once again, good morning. This is the New York City Board of Standards and Appeals review session for July 10th, 2023. There's no public testimony during the review session. Are we good?
Gracie, can you hear us?
We can hear you. We just can't see you on the screen.
Well, no, I turned my camera off. It's okay.
Okay, great.
So we'll commence with the adjournments. Item number 1, 2017-269 BZ, 65 Grasimere Avenue, Staten Island. Item number 2, 2019-198, 40-17, 28th Avenue, Queens. Item number 3, 2021-1 BZ, 3118 37th Street, Queens. The following items are postponed. Item number 4, 250-00 BZ, 521-541 LaGuardia Place, Manhattan. Item number 5, 2023-06 BZ, 1830 East 26th Street, Brooklyn. Maybe I'll put my video on. East 26th Street, Brooklyn. Item number 6, 2023-13A, 34 Carlton Place, Staten Island. Deferrals. Item number 7, 2020-85 BZ, 114 Kingsland Avenue, Brooklyn. Item number 8, 2021-41 BZ, 2838 Cummings Street, Manhattan. The following are decisions. Item number 9, 1-11 BZ, 189-191 Atlantic Avenue, Brooklyn.
Okay, the applicant provided an update regarding its status. Did everybody have a chance to review it? Were you all satisfied? Okay, so was I. So I make a motion to approve.
Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 10, 26-94 BZ, 141 Manson Avenue, Staten Island.
No submissions were required. Make a motion to approve.
Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 11, 16795 BZ, 12120 Springfield Boulevard, Queens.
Everybody was satisfied with the chicken. Great, thank you. Motion to approve.
Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 12, 30879 BZ, 43 Clark Street, Brooklyn.
Okay, the applicant was asked to provide a response regarding the curing of violation and timelines to obtain CO. I was satisfied with the information provided. Was everybody okay with the response?
Yes.
Good, thank you. So I make a motion to approve for a 2-year extension of time.
Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 13. Sorry about that. 36487BZ, 1710, 1720 Flatbush Avenue, Brooklyn.
No submission was required. I make a motion to approve with conditions that no vehicles shall be parked on the sidewalk site, including outdoor areas shall be maintained free of debris. With that, motion to approve.
Chair Shanda,
Aye.
Vice Chair Shavetta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 14, 57537BZ, 60-93 Flushing Avenue, Queens.
So applicant has revised the plan and has shifted the position of the 4 dispensers to line up with 61st Street, and the canopy length has been increased slightly from 96 feet to 98. I was okay with the change, and I don't think it alters the findings, but I wanted to make sure if commissioners had any other commissioners. Okay, so everybody's nodding, saying everything is okay. So I then make a motion to approve with conditions that sidewalks shall be repaired prior to obtaining CO.
Chair Shanda,
Aye.
Vice Chair Shavetta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. There's a sticking, sorry. Item number 15, 2018-52BZ, 159 Borum Street, Brooklyn.
So updated construction photos were provided and showing that the building foundation is complete and up to 4 stories of the structure has been built already. And an estimated timeline also has been provided. And the estimate is to obtain that by August of 2027, a certificate of occupancy would be obtained. Is everybody satisfied with the information provided? Thank you. So I then make a motion to approve.
Chair Shanda,
Just one,
Oh, I'm
Sorry,
sorry.
1 second.
do you want the 4-year extension? Do you want it to be from today?
I think isn't that what the applicant wanted from the time of the
Yeah.
grant?
Okay, that'd be-
Yes.
okay.
Yeah, approve, and this would be extension from the time of the grant.
Chair Shanda,
Aye, thank you.
Vice Chair Shavetta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 16, 2019-16BZ, 250-01 Northern Boulevard, Queens.
Just 1 second. Okay, so we received revised plans in response to board comments. Did everybody have a chance to? Okay, everybody seems to be satisfied. If satisfied, so I make a motion to approve. Oh, do you have any questions?
Sure. I just want to state for the record that we had a clarification from the community board as to what the concerns were with some of the people who voted against it. The primary concerns, and I'm paraphrasing here, is that they didn't want to lose the playground access and they have traffic concerns.
Thank you. Yes. Okay,
Motion to approve.
motion to approve.
Chair Shanda,
Aye.
Vice Chair Shavetta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 17. Wait 1 second. Item number 17, 2022-3BZY, 4923 Second Avenue, Brooklyn.
Sorry, I'm just. Okay, we received a revised statement of facts. Everybody satisfied? Okay, thank you. So make a motion to approve.
Chair Shanda,
Aye.
Vice Chair Shavetta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta.
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 18, 2022-60A, 35 Herkimer Place, Brooklyn.
Okay. So we received some submissions in the last few days. I hope everybody had a chance to review it. We also received a letter from the Community Board's Housing and Land Use Committee expressing further clarifying why they were not satisfied with the response that was provided by the applicant. And applicant has provided further clarification in response to the community board's comments. Specifically, the applicant states that the owner intends to reissue an RFP to a private hospitality industry to operate this boutique type of hotel. And the completion cost was based on standard Marshall's valuation system. And furthermore, the owner intends to develop the existing structure as a boutique hotel. I further want to add to that is that what the board is granting is a vesting of a hotel. Now, should the applicant choose to pursue a different use, it would be only what I would assume without, as of right, would be only the uses that would be permitted in the manufacturing district, in an M11 zoning district. So that's the only range of uses that this site can afford. So I just wanted to clarify that and put that on record. The applicant has also indicated through photos that graffiti has been removed, and they will continue to have a weekly cleanup process. So I was satisfied with the information that was provided and also the financial information, but I wanted to just make sure the commissioners were satisfied with everything and if all their questions were responded to. Commissioner Otley-Brown, specifically, you had some questions regarding the finance.
Yeah, I had questions about the substantial expenditures, and they revised these substantial expenditures to not include the purchase price and holding costs, as I suggested, resulting in them having spent 66% of the total cost. So I was satisfied with that. And then as for the serious loss, they showed us that there would be an additional 3.9 million to convert this site to an office building, bringing the total cost to 8.4 million, whereas the value on opening day would only be 6.3 million if it were an office building. So they showed a loss in cost expended of 2.2 million. And then they showed us what the relative value of a hotel versus an office building would be as of opening day. And that's a loss in relative value of 7.4 million. And so I was satisfied with this serious loss finding as well. I have no more questions.
Okay. Any other comments from any of the commissioners? Commissioner Shetta?
Yeah, thank you, Chair. Just want to say that the picture they submitted, I asked them originally to give us pictures from 2021. In their submission, they are saying that the pictures are from July 21 to December 21. The pictures I've seen and I'm satisfied with them is just from December 2021. And yeah, regarding the community board concerns, we were concerned about the management, about the use, and I believe that the response from the applicant is kind of like satisfactory, at least to me, and hopefully he's going to be coordinating with the community.
Okay. Thank you. Any other comments from any of the commissioners? Okay, thank you. I then make a motion to approve.
Chair Shanda,
Aye.
Vice Chair Shibata,
Aye.
Commissioner Otley-Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 19, 2022-97A and 98, 2022-98A. This is 209-215 Claremont Avenue, Staten Island.
The applicant has provided on the necessary responses. Everybody was satisfied with the response provided. Good. Thank you. And I therefore make a motion to approve.
Chair Shanda,
Aye.
Vice Chair Shibata,
Aye.
Commissioner Otley-Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 20, 2019-304BZ, 2019-305A, 180 East 132nd Street, the Bronx.
Okay, so we finally have all the sign-offs, secret sign-off. That was the only thing we were waiting for to vote. So we now also have the DOT sign-off, and the plans have been revised, includes all the environmental notes and comments. So I then make a motion to approve with the following conditions. One is secure necessary approvals for SCP plan prior to obtaining work permit and meet the fire department requirements. And since the proposed development requires a waiver pursuant to General City Law, Section 36, the applicant shall provide access to the site, and the owner would be responsible for the cost of designing and implementing improvements to the private access way identified as the private street on the BSA approved plan. within the easement area. The owner is also responsible for designing and implementing improvements to the fire access road within the property. In addition, the owner and the management company will maintain, shall maintain both the private access way and the fire access road. In addition, DOT Division of Bridges will, in coordination, DOT Division of Bridges coordination will be ongoing, and the applicant will continue to coordinate with the New York City DOT Division of Bridges. Those are my conditions. Motion, everybody. Okay. Motion to grant. This was a complicated project, first of all, and I really want to thank the BSA team. It required a lot of coordination amongst a lot of city agencies, and also the applicant worked with our project management team, and I want to thank the project management team of the applicant, and especially our BSA team. So I really want to thank you all for getting this through the finish line. Thank you.
Chair Shonda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Excuse me, application has been granted. Item number 21. Item number 21, 2022-52 BZ, 2221 East 13th Street, Brooklyn.
Okay, no submission was required. I make a motion to approve with the standard conditions that the removal of exterior walls and or joist in excess of those indicated on the BSA approved plan shall void the special permit. With that, make a motion to approve.
Chair Shonda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Special order calendar items, continued hearing, item number 22, 31953 BZ, 1135 East 222nd Street, the Bronx.
Okay, this has been a very troubling project from day one, and we are at the second hearing, and we still seem to be not able to get through simple message that we had imparted at the last hearing. And I think you all got the chance to receive the correspondence that transpired between our project manager and the applicant's counsel, the property owner's counsel. And it is extremely disturbing and frustrating, despite all the assistance that we have been given. There is such a lack of interest. I wouldn't call it interest, lack of any.
Classic failure to prosecute.
Hmm?
Classic failure to prosecute.
The lawyer has spoken, classic failure to prosecute. So the correspondence between the applicant's rep and the BSA staff was posted in the shared point, and the operator's legal counsel's response is not only not acceptable, it is highly unprofessional. The legal counsel fails to see his responsibility towards his client and shows his unwillingness to understand the process and not respond to the board's comments. At the last hearing, the board was very clear about the additional improvements that must be made to the site and to revise the site plan, because the site plan that we have was the initial submission, which had a lot of incorrect information. So we had asked the applicant to make those corrections and reflect those on the plans and provide a signed and sealed document. And the applicant at that time had stated that they needed to do a survey to ensure that the property line is what it is before they could install the bollards. So it was the applicant who volunteered to do a survey. And so we were waiting for the survey for the applicant to then determine what was the boundary of the property, and therefore, based on that, locate the bollards. The ball is on their court, has been on their court.
Madam Chair, may I interrupt you? I don't know if
Yes.
it's appropriate. Just checking my messages for whatever, but the owner's attorney sent me an email at 10:33 a.m.
Very kind of him.
Pictures of my client's property. Should I forward it to all the commissioners so they can look? I mean, I know you're not gonna have time to look at it.
We won't have the time to look at, you can forward it, but this is not acceptable. You cannot submit something on the day of. We would typically adjourn cases when nothing has been submitted. We have dragged this partly because this is such a problematic site, and we want to stay on top of this site and want to have this problem corrected. But the applicant is every time fails to do that, and on the day of the hearing is submitting bits and pieces of information. This is not acceptable. I am not going to accept it. I'm going to look at it, but I'm not going to accept it as a submission.
Okay, I just sent it to you.
It is a waste of our BSA teams, project managers, our time, everything. And it's not fair to all the other applicants who do their time, who submit everything on time. We may not like everything that they submit, but they submit based on the response that they believe is the right response.
Yeah, I want to say that this is the third hearing of this.
This case.
Third hearing,
The
you're,
Third hearing.
first one
yes,
was
thank you.
postponed,
Right.
And it was December 5th.
You're,
2020.
yes.
The second one was January 23rd, and then.
Commissioner Sheta, could you please turn on your mic? We can't hear you.
Yeah, it's not on.
Oh, sorry. Is that better?
Thank you.
Yeah, so this is the third trial for that applicant. First one was December 5th, 2020. Second was January 23, and then April 24th. If you look at the dates, we tried to like accelerate this case, expedite it because of the conditions at the site. I don't believe we should give any further chances to this applicant and to this owner.
And it may,
I-
did the board see the commission, the
Okay,
community
yes,
board's
I-
letters?
I just saw the photos
Yeah.
and it's very interesting that they would submit photos to us that showed that they striped the parking lot and that the cars are hanging
Hanging over
over
the
the
parking
lot
structure.
onto the sidewalk. It's
Yeah.
I
like,
thought you'd find that image.
Yeah,
I don't even understand how you would
right.
represent your client in that
Yeah.
fashion.
I believe
Okay,
there is an issue in the connection between the owner of this business
I feel,
and his counsel. And if this issue is not resolved, and if we're not getting a submission that's meaningful and responsive, next hearing, we should vote on this. I suggest that we close it today and prepare it for a vote or reopen next hearing.
I think we
Uh,
should first send a letter of dismissal to the owner.
yes. Vice Chair Shabbat.
Sure, so as Commissioner Sheta stated, this was first adjourned from December 5th, so that's 8 months of the BSA working with the applicant. Now, the BSA is known for helping along applicants, but it can't be expected to do the legwork for the applicant, and that's what that email basically stated. He expected that our managers would reach out to the owner and tell them what they needed to do, and that's simply not, that they have to do their job. So I would support sending a dismissal letter directly to the owner, so the owner is aware. So I'm not sure what the owner knows or doesn't know about what's happening with this proceeding. And then, as Commissioner Sheta suggested, on the next date, we should vote.
Yes. I agree. Commissioner Otley Brown, do you have anything additional to state?
I just want to say that the community board submitted a detailed letter that basically called for us to revoke the variance because of repeated non-compliance here and their lack of confidence that the owner of this property understood what it meant to have a variance and not be a nuisance to the community.
There was also an email from that I.
And the
from
council member.
council member.
Yes,
Yeah.
Council Member Riley. Yeah. Anything addition you have to say, Commissioner Sheta?
No, I just, like I said, next hearing, either reopen
Got it.
and continue quickly and get this done, or just vote.
Commissioner Yoon, thank you. Commissioner Yoon?
Yeah, I agree with everything that's been stated. And unfortunately, yeah, the owner, it's also their responsibility to retain proper representation here. And they seem to have been given that opportunity, but reaching out to them directly to make sure that they're aware of what's happening. I'm in support of that.
I agree with you all. I am going to suggest, I don't know if the applicant, the owner and its legal counsel is going to be at the hearing, but please let the applicant know the drawing, the photos that's been provided. It's not, we're not asking for just information just for the sake of it. The information has to respond to the comments. And the applicant, the very first discussion that we had was the sidewalk is not yours. The sidewalk is city owned. And that was the whole reason why the owner said, well, we should then do a survey to ensure what the property boundary is. You have not shown a property boundary. You have not done the survey. And despite that, I hate to use the word, the owner and the council has the audacity to submit a plan, submit a photo which shows that cars are parked outside on the sidewalk. I don't like to use this terminology, but it is getting frustrating for me and for the commission. And I think I speak for them when I say it is not acceptable. And I am agreeing with my fellow commissioners that we should send a letter to dismiss a letter to the property owner, and then and at today's hearing, we are going to close it and then vote it out. And what I want the owner to know is what this does is that you do not have the right, you would not have the right to use this site as an auto repair facility, period. It reverts back to what the zoning, underlying zoning allows. And it is then up to DOB to come and issue violations. It is no longer in our jurisdiction. It is for DOB to issue violations. And that is the fate you have chosen. And I unfortunately our team has provided a lot of assistance, and this is going nowhere. Thank you. I'm sorry I had to say all of this.
Okay, item number 23, 91559 BZ, 5912 Fresh Pond Road, Queens.
Okay. All right, the initial hearing on this application was held on April 24th. The applicant has provided its response to the comments that were raised at the hearing. Some of the improvements have been made, including removing the vending machine, fencing, and slats have been replaced. Photos have been provided of the improvements made. The fencing does look better, and I do appreciate those changes that's been made. The applicant is also proposing to revise the design by providing a trash enclosure. And that would not only just accommodate the trash enclosure, but also the drums that store used oil for disposal, and also has added some planting to around the trash enclosure. So I think these were all good changes, and I appreciate the applicant hearing our comments. Now, regarding the installation of the steel shield to minimize the lumen, that should be done now, because I don't think there is going to be, I don't know to what extent the canopy light is going to cause that much of lumen spread that would go across the property line. It's really the light that is at the property line that is causing the lumen spread. So shield should be provided now, unless you're planning to completely change the structure and provide a different lighting equipment. And also diagrammatically show the expected lumen level from the canopies. Now, regarding the street tree planting along 61st Street, I recognize that it's not a requirement. My recommendation was to reach out to the Department of Parks to see if tree planting can be added along 61st Street, because this would reduce some of the vehicular parking onto the sidewalk, which is destroying the sidewalk and is almost becoming a liability for this property owner. So it's really an urban design solution to minimize these kind of sidewalk parking. Those are my comments. Vice Chair Shibata.
Thank you. I agree with your comments. I think the street trees, it's the nicest way, the most aesthetic way to solve this problem. I hope the applicant can pursue it, and I have no further comments.
Thank you. Commissioner Otley Brown.
I want to add to your comments that they did update their statement in response to my question that correctly defines what they mean by passive auto parking, which means to be parking for repaired cars that are awaiting your pickup. And I'm satisfied with that definition.
Okay, yes, thank you. That was a question we had. Yes, it's a new terminology. Maybe we can use it in other passive auto parking. Commissioner Shetta.
Thank you, Chair. I second your comment regarding the shielding the light fixtures. They did mention in their submission that they are not replacing the entire system, they're just gonna shield it. So if this is the case, I would suggest that they do the shielding sooner than later. The other point is regarding the drums. They indicated that they're gonna be storing the drums inside the trash enclosure. My only concern is that when handling the trash bin, if one of these drums got hit or so, and I'm sure that these drums gonna be containing oils and maybe potentially hazardous materials, you don't want to be like getting at an issue like that. If you can, within the trash enclosure footprint, if you can specify like a specific space to store these drums away from the like in and out of the equipment that's gonna be moving the trash bin, that would be like much safer for you.
I thought, unless I misread the drawings, and I just want to open the drawings. Just give me a second. I'm looking at the drawings that were just submitted. Yeah, I think if you look at, Commissioner, if you look at drawings A004, the enclosure will have two partitions. One partition where the trash bin will be located, and the other partition that would have the drums. There's a wall separating the two storage spaces. A004.
004, okay. Yes, I see that. Thank you so much. Yes,
Is
that's
that-
what I was talking about.
That responds to your
Yeah,
concern?
yeah, it does.
Okay.
Yes, thank you.
Thank you. Commissioner Yoon?
Thank you. I agree with your comments. I have nothing further.
Okay, thank you. All right. Next case, please.
Item number 24, 860, I'm sorry, 82067 BZ, 41 Barker Street, Staten Island.
The initial hearing on this application was held on February 6th. The applicant has provided its response to the comments that were raised at the hearing. Statement of facts have been revised regarding substantial prejudice without a waiver. The applicant was asked if additional parking spaces would be needed in response to a concern that was raised by the community board. The applicant does not wish to amend the plan for more parking. Though I had asked for an operational plan and that was not provided. And the reason I'd requested the operational plan was to see that vehicles can be maneuvered to keep them from blocking the sidewalk. So I would like the applicant to respond to that at the hearing. Site improvements have been made, including striping of the parking spaces with bollards. Excess signages have been removed, and the site has been cleared of auto parts and debris. And photos have been provided, though the photo did not show the signage removed, and also all the landscape. I stand corrected. I think we received a very Friday submission, right? Yes, yes. So it did respond to my, those were my comments with regards to signage and additional landscaping. It wasn't quite clear from the earlier photographs, but the subsequent photographs did show the landscaping around the site. So I was satisfied with that. The applicant stated that the landscaping plan is consistent with the previously approved plan. I went back and I looked at it. It is. It's just the diagrammatic representations are different. So that's okay. The applicant intends to renew the spray booth permit in 2024 when it is, that's when it expires. I think should we proceed to close and approve this application, I want to make a condition on this with regards to the spray booth, and I want to hear feedback from the commissioners now, that if we approve it, this extension of term, the certification, that certification be renewed and
Spray booth permit.
yeah, I'm sorry,
Permits.
yes, I'm
expires
trying to read
2020.
my notes. That the spray booth permit be renewed and provide us and provide that and revise and should they choose not to renew the spray booth permit, then they should notify the board to revise the plan. In case. That's just a condition. So, and they should submit the renewed spray booth permit once they do that. Either or, it's a either or comment I have. Sorry, Vice Chair Shibata.
Thank you. The only thing I'd like to add is that they did update to show that they have substantial prejudice in that this has been a auto repair shop for 5 decades. And they made that statement in the statement of facts. So I have no comments. I'm satisfied.
Okay, thank you. Commissioner Otley Brown.
I'm satisfied with the way in which the site is shaping up nicely and looking a lot neater and cleaner. I have no additional comments.
Yeah, I agree with you. The site does look a lot cleaner. Commissioner Shetta,
Thank you, Chair. I have nothing further to add.
sorry. Okay, thank you. Commissioner Yoon.
Thank you. I appreciate their responsiveness and I have nothing further.
Thank you. Next.
Item number 25, 112281 BZ, 10514 Astoria Boulevard, Queens.
Okay. So the initial hearing was held on April 25th, and submissions have been made in response to the comments that were raised at that hearing. Signage and landscaping have been revised and restored to the plan. Improvements have been made and we received photos indicating those improvements. Now, with regards to the mezzanine space, we received a letter from the owner's council stating that the access to the mezzanine has been removed. And as a proof of that, a photo has been provided of the staircase leading up to the mezzanine being, removed. Though, based on the photos provided, the mezzanine floor structure still remains. And if there is my earnest request is if there is a need for the mezzanine space, then just consider amending the prior ground. It is not that difficult to put that stair back. So I just want us not, I just want the representation that the applicant is meeting is absolutely clear with the intent, and either you remove the entirety of the mezzanine structure, or if you want to keep the mezzanine structure, then just amend the plan and go through an amendment with a justification as to why that space is needed. And I'm open to it, and I want to hear from the commissioners what they think about it. Vice Chair Shibata.
I am open to it. I also want to say that this is a good case of how an applicant is working with the BSA. There was direct communication, there was back and forth, there was changing of plans leading up to this, so we can actually have a productive hearing. And this is a great example of that. I have no further comment.
Okay, thank you. Commissioner Otley Brown.
I have no problem with them seeking an amendment to variance, but as it would be an amendment to variance, they need to revisit the 5 findings.
Yes. Well, in terms of the neighborhood character, I don't think there would be much because there is not any physical change. It's all interior. The uniqueness part has been established. It's really the finance and the minimal. The self-created also has been established as the prior. So we're looking at B and E. Right.
Oh, B and E should be substantial, but they should just give all,
Right.
yeah, words to
Respond
the other ones.
Right, they
basically. Yes,
yeah.
but B and E should be the ones that are fleshed out the most.
Absolutely, right. That's what I wanted to
Mm.
clarify. Yes, okay. Commissioner Sheta.
Thank you, Chair. I'm open to consider an amendment if you want to go that route, but if the representation is not to pursue an amendment and just stay with the previously approved conditions, I believe the O is removal of the mezzanine, not just the staircase. The staircase, if it's bolted to the mezzanine structure, so it's a matter of probably half an hour to get an equipment, lift the flights, put them in, tighten the bolts, and you're done. You're good to go. So they should pick either way to go and just walk the walk to the end. Either remove the basement with the flights or put the flights back and seek an amendment.
Okay, thank you. Commissioner Yoon.
Thank you. I had the same reaction about the mezzanine. I agree. I have nothing further. Yeah, I have nothing further to add.
Okay, thank you. Next case, please.
Item number 26, 8-04BZ, 7815 Parsons Boulevard, Queens.
Okay. The initial hearing on this application was held on March 24th. Applicant has provided a detailed response to most of the comments that were raised at the hearing. Revised, where I think I have comments are revised plans clarifying the proposed and existing are of the notes regarding the noise added to the proposed roof bulkhead is not legible, partly because of the lighter text color and the overlapping text. So that needs to be corrected. It's really a drafting issue. Indicate the distance between the proposed acoustic fence and the parapet wall on the plan. And the plan does not clarify the type of fence that is to be maintained at the street level. Regarding the school size, the applicant has provided a comparison chart of schools in the vicinity. I think this was a question Commissioner Otley Brown had, so I would look towards her to see if she had an issue. To me, it seemed okay. With regards to the ADA compliance, I had raised that question, and the question was more to ensure that the building entrance will be ADA compliant, as the current building seems to lack it. If you look at the existing plan, to get to the elevator, one has to go through a set of stairs. There aren't any ramps leading up to the building from the from the playground level to the building to access the elevator. So that's why I had raised the question of ADA compliance. I really didn't question the elevator being ADA compliant. It was the access to the building. So that was the question. So if I wasn't clear, I'm just making that now a statement now. Clarification has been provided regarding the use of the synagogue by public and the service hours, how those would be conducted, and these would be conducted outside the school hours. And also the application has provided clarification regarding the 2 open ECB violations, which seem to be more pertaining to the certificate of occupancy and the rooftop play area, which hopefully, should this get approved and the applicant make those changes, that should correct the certificate of occupancy issue. Those are my comments. Vice Chair Shibeta.
Nothing further from me, Chair.
Thank you. Commissioner Otley Brown?
Yes, they addressed my questions regarding the e-finding as to where they fall in the range of gross square footage per student. They used 4 nearby schools with ranges from 87 square feet per student to 435 square feet per student. They talked about the 2 schools that were most representative of the subject school having 135 gross square feet per student. And they stated that this project would result in 88 gross square feet per student, which is at the low end of the range. So I'm satisfied. I have no other questions.
Okay, good. Thank you. Commissioner Shetter?
Thank you, Chair. I see that they provided the sections that I advised them to provide last hearing. So I'm satisfied with these sections. I also want to actually thank the applicant for the very good presentation for the scope of the waivers. And on the drawings, I do believe that this is one of the cases that's like the drawing sets, I would say, one of the best. So I want to thank the applicant for that. And I'm satisfied with the application.
Okay. Thank you. Commissioner Yoon?
Thank you. The applicant did correct a statement that they had made at the last hearing about whether the rooftop play area was going to be enlarged or not. They thought it was all existing, but it actually is going to be enlarged by this improvement. And my one request is to tell us what the total roof play area is and by how much the existing is being enlarged. I couldn't find that information anywhere. And this is the area within the 10-foot-6 high fence.
Mm-hmm.
I have nothing further.
I thought it seemed to me like the entire roof was going to be the play area.
No, it can't be because the fence is set away from the parapet. And it's
Okay.
only the fenced area. So we also need to know that distance from the fence and the parapet. And then from there, did you, and your Commissioner Yoon's point is what is the actual area that would be used for the play area?
Yes.
Okay.
And that needs to be noted.
Thank you.
Thank you. And I want to thank Commissioner Yoon for picking up on that, the rooftop play area being enlarged. Yes, the drawings have been made much clearer regarding the existing level of existing non-compliance, variants that were granted, and the new set of non-compliance. Though my only little problem was when I was looking at the graphics, because of the overlapping of the graphics, I wasn't able to read the information. And these are critical information that DOB needs to have when they're reviewing the plans. I see Ms. Benke's hand up. Ms. Benke?
Yes, thank you. The applicant submitted a tech memo regarding the environmental aspects because the initial application had an EAS. So we issued comments on the tech memo and we're waiting for a response. And we also asked them to include the square footage of the play area to be more specific on the plans.
Great. And I think we need to be careful when we do say the play area, it is just the play area that is within the fence and not the total roof. So, or we can be on the worst case scenario, whichever way it is. And I leave that up to the expertise of Ms. Benke in terms of environmental review, how it should be considered.
Okay.
Any other questions or comments? If not, let's move on. Thank you, Ms. Benke.
New cases on the SOC calendar, item number 2711-93BZ, 4645 Kissimmee Boulevard, Queens.
Okay, we have received proof of service of initial filing and hearing notices. I did not see a community board vote on this. This is an application for an extension of term of a previously approved eating and drinking establishment that will expire. The term will expires in March of 2024. And applicant is also seeking an extension of time to obtain a certificate of occupancy, which expired back in 2015, and a waiver of board's rule. A proof of continuous use is not required in this case, since the term has not expired. Applicant has provided a compliance report, but needs to provide compliance report with all the prior grants from 1994 onwards. I think it only shows the last year or two. With regards to the submission, I have some comments. Applicant needs to provide photos of the interior parking space. Per 1994 grant, there were several state conditions that were required, including providing a proof of so the applicant needs to provide these photos to indicate that the conditions are being met of the prior grants. Fencing, landscaping were part of the conditions, lighting directed away, downwards and away from the property line was another part of the condition. Another condition is attended parking being provided during business hours. So I would like to know what are the hours of operations and are the gates to the parking area locked after business hours, and is there an attended parking? What is the pickup hour of the garbage? Provide photos of the sidewalk conditions. With regards to the violation, it seems there is one open DOB and 12 ECB violations, and though the open violations were paid. Now, it's been 7 years since the current owner took title, yet a certificate of occupancy has not been obtained. So I need more clarification as to the delay in obtaining a certificate of occupancy. Sorry, I meant certificate of occupancy in the previous one, not certificate of occupation. Certificate of occupancy. Also, some of the open violations date back to 2010, 2017. So I need more clarification as to what they are about and why it's taking so long in closing those. Provide a status update regarding the obtaining a CO. And resolving the ECB violation, and provide a timeline to resolve these violations and obtaining the CO. So those are my comments. I think, Ms. Benke, is there some issues with the SECRA?
We need a type 2 checklist. We didn't get one for this application.
Okay, thank you. So we need a type 2 checklist. Okay. Thank you. Vice Chair Shibata.
Thank you, Chair. Nothing further from me.
Thank you. Commissioner Otley Brown.
I agree with you, Chair, that we need to see photos of the interior parking lot. Number one, to ensure that there are no food storage containers anymore, which were there in the previous renewal, and also to see the state of the garbage enclosure, which also was problematic the first time.
Thank you. Commissioner Shetta.
Yeah, I'm in favor of submitting pictures for the parking space for the parking area. The only thing that caught my eye on this application is when I looked at the previously submitted, previously approved plans, I can see that they have a fence on the northern and the northern eastern property lines. The type of fences are not specified on the previously approved plans. But because of that, like the way they were represented, I do believe that they kind of like block, maybe masonry block walls. But when I look at Google Images, I can see that even a fence exists along these two property lines. Okay. Apparently they are, especially on the northeastern side, apparently they are counting on the neighbors' fence. So I just, if they can clarify about that by submitting some photos, that would be helpful. Other than that, I have nothing further on this application.
Okay, thank you. Commissioner Yoon.
Thank you. I agree with your comments. The one thing I want to note is that in the statement of facts, they do provide a timeline that they anticipate 6 months to get the job approved and get a TCO, with another 3 to 6 for FCO, thereby requesting a 1.5 years for their extension of time to obtain CO. So they're asking for a 10-year term plus the 1.5-year extension of time. I did a little digging, and of course, their last C of O was from 1996. And this has been operating as a restaurant since 2001. And so I also had questions about what's taken so long, even, I mean, the current owner has been in place for 7 years. So seems like we need some explanation for why the C of O hasn't been obtained so far, with some assurance that it will be obtained within the next 1.5 years. Otherwise, I agree with everyone else's comments and I have nothing further.
Okay, thank you. I somehow or the other missed that part of the 1.5.
Carlos, hand us up. The executive director's hand us up.
Oh, yes, Executive Director Costanza.
Yes, Madam Chair and board members, I'm sorry, I caught it late, but I know it was suggested that, I'm just looking at this, if this is a pre-1961 case, I'm sorry, I'm looking at some of the project descriptions.
This is a 1958, a variance was granted, but that was under a different BZ number. And then I think in 1994, a special permit under zoning resolution section 11-413 for a change of use was required. And that's where I think this number 11-93 BZ, that's when it started, 1994.
Yeah, I just think a note to council is just in case, I'll double check again, but again, even under the 11-413, the history of this is relevant all the way to the inception of the variance, because this is guided by the provisions of 11-4-1. So I'm just looking back at the history of some of the project descriptions, and I think they bounce around a little bit, so just note to councils, just to, at the summation of this application, it should be clarified what's the guiding sections and the history on this site.
Okay,
Thank you.
thank you. Okay.
Once again, item number 285412 BZ 6539 102nd Street, Queens.
Oh, we have moved on to the new case,
Right.
right?
Only cases. The next case. Amy,
The
I'm
next,
sorry.
next new case, sorry.
Yes, sorry.
Okay, all right, thank you. Proof of service of extension of time is not required. This is an application for an extension of time to develop a two-family mixed-use residence at the subject lot. Back in 2014, bulk variance was granted for a two-story mixed-use residential building. The applicant has provided a reason for the delay, and a status update has been provided. I think given the site being a very small site, it's a very small project. I can understand the difficulty in securing financing, especially what we are going through. So I'm totally satisfied with granting an extension of time. Vice Chair Shibata,
I'm satisfied with this application. Thank you, Chair.
thank you. Commissioner Otley Brown.
Did they give us how much time was needed or give us a timeline to completion other than that the application has been filed with DOB?
Ooh, that's a good question. I actually don't have no,
No.
I don't.
They didn't-
I was waiting
No.
for that.
Right.
Okay.
Yeah,
Other than that, I'm certainly sympathetic to this case.
okay, right. That's a good catch. So I think I was quite taken in by the reason as to the delay. I completely forget. Yeah, it seems justifiable. But I didn't go through. So they need to provide a timeline. So please, at the hearing, do let us know what the timeline is to obtain the necessary sign-offs to obtain a CO. Thank you. Thank you for that catch. Commissioner Sheta.
Thank you, Chair. I'm satisfied with the application. The only thing is the second paragraph on the statement of fact. I believe this is a typo. It says this application, the previously approved, the previously filed. So I believe they meant this application previously filed NB permit with the DOB. So they need just fix that, and I'm satisfied with the application.
Okay. Commissioner Yoon.
Thank you. I have nothing further.
Okay. Right. Let's go to next case.
Item number 29-11-13 BZ 346 Broadway, Manhattan.
All right. We received proof of service of initial filing and hearing notice. I do not see a community board vote on this. This is an application for an extension of term to continue to provide a garage in the subject building. I went to the site. It looks in very good condition, and there's a garage. I really don't, and I went through all the documents that's been provided. I'm satisfied with the submission. I have no comments. I'm satisfied with extending the term. Vice Chair Shabeta,
Thank you, Chair. I'm also satisfied.
thank you. Commissioner Otley Brown,
I am satisfied.
thank you. Commissioner Shetta,
I'm satisfied with the application. I just want to highlight that we take no position on the structural safety of the floors or the building because of the use of the cellar and the basement. This is beyond our scope. Thank
Yes.
you.
okay. Okay, thank you. Commissioner Yoon,
Thank you. I'm satisfied.
thank you. By the way, if you have not had a chance to go to the site, just to walk around the building.
It's very nice.
It is a remarkable old pre-war building with such amazing details, and it's a historic landmark. So it is a beautiful building.
And it used to be DCAS portfolio.
Yes, it was a city's, I unfortunately never had the opportunity to go there. It's kind of unfortunate, but yeah. All right. Thank you.
Okay, appeals calendar, continued hearing items, item number 30, 2022 to 2022, 20A to 2022, 22A, 724, 726, 728 Richmond Avenue, Richmond Terrace, Staten Island.
Okay, the application was last heard on May 8th. And we have received a revised set of plans. And the plan basically shows an 18-foot wide curb cut for the eastern portion of the building, and one voluntary parking space for each of the three zoning lots. That was one of the comments that we wanted the applicant to clarify. So I was satisfied with the corrections that's been submitted. Any questions or comments, Vice Chair Shabeta?
None from me, Chair. Thank you.
Okay, thank you. Commissioner Otley Brown.
I have no additional comments.
Okay, thank you. Commissioner Shetta.
Thank you, Chair. Same here.
Okay, thank you. Commissioner Yoon.
Yeah, thank you to the applicant for making the changes requested. I have nothing further.
Thank you. Okay, right.
New cases on the appeals calendar, item number 30, 2022, 28A through 2022, 38, 15, 17, 19 Bedell Street, Staten Island.
Okay. We received proof of initial filing and hearing notice. This is an application for common law vesting to complete construction of 3 single-family developments at the subject site. There are 3 zoning lots, so the applicant has submitted a timeline. I just have very basic questions before even I get to the vesting finding. And for me, that is to do with the zoning regulations. And I would like the applicant to clarify that. And I think it would be helpful for me to hear that at the hearing. I felt that the statement of fact lacked the clarity regarding the zoning districts that was in place at the time of issuance of the building permit for new construction in early 2005, and the subsequent changes in the zoning district affecting the subject site. The statement of fact states that the site was rezoned from C11 to R3X. Well, C11 is not a standalone zoning district. It's a commercial overlay over a residential zoning district. So based on the historic map, I looked at the historic maps. It seems that the sites were rezoned, where they were zoned R3-2 with a C11 overlay and has been a part of the South Richmond Special District. It was then rezoned to R3X with a C11 overlay in September of 2022. That's the adopted date of the map. And on 10/27/2005, C11 overlay was removed. So my question is, it seems that the change was primarily the removal of the C11 overlay from 2005. R3X was in place since 2002. So since R3X was in place from September of 2002, the applicant needs to clarify what changed in R3X regulation, if any, in 2005. Based on the plan submitted, an attached house is proposed. And whereas R3X currently, and I believe since 1990, permitted only 1 and 2 family detached homes. So I need a clarification as to what was permitted when the plans were approved by DOB. And also to that, the applicant needs to submit a DOB approved plan. I did not see anything in the file. So that takes me to the questions regarding the vesting. We did receive a letter from DOB dated June 29, stating that the permit was lawfully issued. Even though that states this, I would like the applicant to clarify. And if I'm wrong, I would definitely like to understand that. This is really would be a helpful exercise for me. And the application information should be very clear in stating that, because the zoning information is incorrect. To determine the common law vesting, the board applies the Putnam-Armstrong test. And per Putnam-Armstrong, the applicant needs to establish that substantial construction was undertaken and substantial expenditures were made prior to the effective date of the zoning change, and that there would be a serious loss if denied. So with regards to the substantial construction, the applicant has stated that the construction commenced in 2005, and the excavation and foundations were already completed prior to the adoption of the zoning text change of 10/27/2005. So from that point of view, it meets the vesting requirement as stated. Though, like I said, my question regarding the zoning is a larger question, so that all can change if that gets revised. With regards to the substantial expenditure, the applicant states, and I quote, "At the time of the enactment of the zoning change, the owner had expended tens of thousands of dollars in filing plans and securing approvals and excavation and pouring of foundations. The applicant needs to provide proof of financial expenditure made and payments made to the contractor and fees paid to the architect, engineers, etc. Those are some of the basic thresholds that we look for. Commissioner Otley Brown can shed some light and provide more clarity on this. With regards to serious loss, the applicant needs to elaborate on the serious loss if not vested. Would it result in demolition of the structure built and submission of revised plan based on the statement of fact timelines of events from 2005 to date? It is evident that the property owner has been trying to develop the properties based on 3 lawfully issued permits in 2005, but for various reasons, it has seen setbacks. But those are my questions and comments. Vice Chair Shibata.
Thank you. I believe the applicant submitted
Yes.
checks with regard to expenditures.
They did? I couldn't
The
find it in the
checks, the
file.
oldest checks unfortunately date back to 2016. And so there's a disconnect between the evidence that they provided and the claims they made.
I say we go directly to you because that's the only comments I have.
Oh, okay.
It was a submission made on this application in June. I'm not sure if
June
we
29th.
all looked at them. In June 22nd.
Yeah,
June
I've
22nd.
gone through.
Yeah.
Yeah, it was a
all of the
run on,
submissions.
unfortunately, it was a run on and I.
And June 29th. Yeah.
Yeah, no,
Unfortunately.
I've seen everything and I've looked at all of the checks unless they today have submitted new checks. All the checks are from 2016 and forward, not backwards. And so the way the statute reads, the proof has to be presented as of the zoning change date. What exactly was going on? And so I want to start by just saying, because I had a number of different requests for clarification. On a whole, I am sympathetic to the small developer who gets caught up in a lot of mishaps that really knock them for a loop, primarily because they are small developers and don't have that kind of money, power to be able to power through all of the different tragedies or problems that occur in trying to develop a property. So I would love for us to work with this applicant here the best that we can. They say that they have proof that they have completed the work by the zoning change date of October 27, 2005. But they don't really provide any proof of that other than a statement that DOB actually did a special audit on whether or not the property had completed its threshold amount of work by the zoning change date, and they accepted the results from the special audit on November 27, 2007. I looked through all of the evidence and I didn't find the documentation from DOB. It would be helpful, because then at least that would prove that first prong. Unfortunately, they had a series of mishaps after that, like the truck driving into the foundations and destroying them, and trying to come up with a solution to secure these foundations with DOB, only to find out that another agency, not checking with them, just backfilled all of the foundations, causing even more of a problem for them. And so also, in talking about the history of this series of events, one of the things the architect did try and do was to try and move forward with what they felt was an as of right under the new zoning project, which would convert the three attached townhouses into 2 detached homes by removing the existing cellar first floor construction from the center home, and then also cutting back the first and the third homes front 10 feet so that it would comply with the front yard regulations. And they make a statement that the application was permitted or it was approved in February 8th, 2018. However, when they actually submitted plans in order to pull those new permits, DOB then disapproved the applications at the end of October. And so we need a statement from them clarifying exactly what happened here, and also a statement that what they did not constitute an abandonment of their vesting, because they literally stopped at that point trying to go with the original project and tried to go with a complying project. So they need to address that issue. They could always argue in their defense that, well, DOB never approved it, and so they never really abandoned it, because no new building permits superseded the original new building
Right.
permits. So that's how I would go if I were them. But anyway, as I said, I'm trying to work with them. As for the substantial money spent by October 27, 2005, they don't have any proof at this point in time that documents the amount of money spent. So I would suggest to them that they use Marshall and Swift or another approved cost, and a cost calculator, thanks for the word, in order to substantiate the money spent, because the foundations were there, and if DOB states that they were there, and somebody clearly paid for them. And so in this case, I would accept from them a recreation of those costs to satisfy that finding. And then as for their serious loss, I think that they did a pretty good job actually in saying that as far as they're concerned, everything that's in place has to be removed. And so what they do is they then talk about all of the costs expended, which they have proof having been expended by 2016. And that the costs amount to about $1 million and change that actually would be lost, not including the purchase price of the land. So they did that correctly. And then they talk about the cost of one new single family home, which I think was a little amplified here, because that would be one huge home to actually cost $1 million to create. And so what they need to do is just refine that argument and say, basically, the new zoning would allow for one single detached home of 4,300 square feet approximately, and using Marshall and Swift costs, that would amount to about this amount of money. And then they could talk about how, which they have done here in the loss table, that the previous zoning allowed for 3 attached homes and the same amount of floor area, but still in 3 different buildings, and how that would sell for more today than the 1 detached home of the same size would sell for. And that to me would at least satisfy serious loss here. So I think they can actually whip this application into shape. It's just that they have to answer those pointed questions that I outlined.
Okay. Those are very helpful. Thank you. Commissioner Shetta.
Thank you, Chair. I believe they are getting there. I had the luck to review the old statement of facts, and I was like very upset. And then we got the second shot of submission. I believe they improved significantly. I believe that they need to give us some evidence. And when I say evidence, I mean maybe photos, documentation, the report for that incident that happened back in the day. Just one thing, and I'm not sure if I'm correct on this, but on the serious loss, the effective date for this was October 27, 2005. I'm not sure if we need to look at what was done up to 2016. I believe we need to look at what was in ground up to 2005, which, if it is correct that the foundation was there, I believe the cost for the foundation and the excavation and the cost for altering these kind of works to accommodate the as of right development after the effective date would be sufficient for us to like consider common law vesting. I don't think we need to look at 2016. We need to go beyond that.
Right.
That's
Oh, no, I agree with you
Yeah.
100% there. I was just talking about what they had presented to us at the time, that it would be 1 million loss based on those checks.
Yeah.
The oldest one was 2016, but you're absolutely right. They should
Thank
go
you.
back to 2005 as their benchmark, for sure.
Right. Yeah. And I think that's what I was looking for. I couldn't find that information. So
You can find nothing in
Right.
the
Yeah, that's
submission.
not in there. I
Yeah.
believe that the
Because-
applicant, because it's an old case, had
Yeah,
a
there
lot of
was
trouble
difficulty
getting
for
all of
the
that
owner.
20-year-old
Unfortunately, we
information.
tried to grab, and that's why there was a couple of postponements on this, that they were trying to gather that information with all the stuff that went on.
and has there also been change in ownership?
There was a brief foreclosure,
Closure,
but they
Foreclosure,
repurchased it. from-
repurchased
Yeah.
it back. Okay.
I would accept from them the incident report for that incident that happened as a proof that in addition to, of course, the DOB audit that indicated that foundation was there. And then the next step for them is to get a Marshall Swift estimate for the foundation
As
cost, like
Commissioner
Commissioner
Otley
Brown indicated,
Yeah.
plus the excavation, and then make their case to us that this is the cost. If we want to change, this is gonna be the implication. We have a
Okay.
serious
Yeah.
loss. And then I do believe it's an easy job for them to achieve. Thank you.
Thank you. Commissioner Yoon?
Thank you. I was also confused by the description of what was permitted or what the zoning regulations were at the time of the approval, but obviously with the DOB audit, understand that it just needs clarification likely for us in the statement of facts. I did look on both DOB and I'm just going to share the Google Maps, so we're all looking at the same thing. Obviously, the onus is on the applicant to provide this documentation, but it is helpful to see what it looked like in as early as 2007. There isn't something from 2005, but you can see the abandoned site, but the 3 clear foundations exist, and up until I think here you can even see it backfilled. And then you see that they start to put the construction fence back together, and once they're permitted again, they start to build the two family homes. I have similar questions as Commissioner Otley Brown has raised, but I did think it was helpful to at least see visuals, which, for an applicant, of course, it's helpful if you have photos that we can look at to show progress throughout the years. But thank goodness for Google Maps. Let's see. I think otherwise, I agree. I'm sympathetic. I understand there is probably a neighbor or two who is called DOB a lot on this case and made life very difficult for the owner. So I have some sympathies to the developer as well and have nothing further.
Yeah, I think I'm just still I understand DOB has granted it. I just, when I saw the C1 with an R3X, I kind of
Yeah,
was
me
like,
too.
okay, let me go back to the history, and hindsight, I wish I had not, but now that I have, I need to ask that question. So I would like the applicant to clarify that.
It wouldn't be at their, it wouldn't be at their expense because they relied on DOB.
Right, and that is a fair enough response. If DOB granted it and providing a DOB approved plan, all of those things would just kind of put this issue to bed. Okay, thank you. Thank you all. Yes, please.
2023-09A, 43 Cunard Avenue, Staten Island.
We received proof of initial filing and proof of hearing notice. We did receive a community board approval on this case. This is an application for GCL 36 to develop a two-family residential building at the subject site that is not fronting on a map street. The zoning analysis chart is a bit confusing. It provides the information for the entire zoning lot, while only one site is subject to GCL 36. With regards to the builder's pavement plan, I want the applicant to provide street trees on the sidewalk. Since the site is in Hillside Preservation Special District, my question is, does it require a city planning certification? And clarify how the approved builder's pavement plan meets the fire code 503.2.3.1 regarding unobstructed street width of 30 foot. Based on the approved builder's pavement plan, the asphalted area will be 20 foot wide. So I'm not sure how it meets the 30 foot width, street width requirement of the fire code. The applicant states that the building will be sprinklered and the signage at the beginning of the driveway will notify the direction that will be provided for the subject building, and that no parking sign will be posted on the driveway, and the hydrant is within 250 feet of all main entrances. All of those would be provided. I do not see any fire department sign off or DEP sign off on this.
We don't need to do GCL 36.
Oh, we don't need oops, I'm sorry.
Fire department only.
We need only fire department. Thank you. Yes. Okay. Thank you. Okay, Vice Chair Shibata.
Thank you, Chair. The only comment I have is that this lot shares a zoning lot with 253, 254, and 120. So I just want a brief statement as to how this configuration is not the reason why they would require a GCL 36. And it is not self-created in that right. And this is, in any event, I don't believe it's going to be an issue because it's only 4 lots. It's only 4 separate lots, and that's well within GCL 36 customary approvals. So I have nothing further. Just a statement to say that this isn't self-created.
Okay, thank you. Commissioner Otley Brown.
I have no additional comment.
Okay, thank you. Commissioner Sheta.
Thank you, Chair. I agree with what's being said. The only thing I would add is that in the statement of facts on page 3, it says access to the subject side is proposed to be accessed via curb that will be 30 by 30, 30 feet by 30 feet paved. I'm not sure if this is consistent with the BBP. I did look at it, and I'm not sure how that statement is consistent with. If they can clarify to me, that would be much appreciated. The second thing, in the statement of facts, again, it says that no turnaround is required for a fire apparatus access road that's minimum 34 feet in improved widths. And it continues to say if it's in the SHPD, the Special Hillside Preservation District, it can be down to 30 feet in width. If this is the case, there is no turnaround required. I believe we do need to get an input from FDNY on that. We want to make sure that what is mentioned in the statement of facts is accurate, and whether the access road satisfies this condition or not. That's all what I have on this case. Thank you.
Thank you. Commissioner Yoon?
Thank you. I had no comments on my review. One question I have is, and this is just to discuss what people should do when you have multiple tax lots on one zoning lot. With the zoning analysis form, they've done the FA, the floor area based on the overall zoning lot, and that's part of the confusion, but at least in practice, that's always how we were told, we're instructed to do zoning analyses as architects, is based on the zoning lot, not on the tax lot, because you can share FAR, of course, across the zoning lot. And so what would be a less confusing way? I can imagine doing it just per the lot, but if in that case their FA exceeds their tax lots zoning ratio, then is that more confusing? How should we instruct applicants to proceed in that case?
Well, I think, first of all, the zoning chart should clearly say it's for the entire zoning lot, include the entire zoning lot with the tax lots, all 4 of them included, which I think was not there. So that's why
It's at the bottom. It's just at the very
It's at the
bottom of the
bottom?
notes. Yeah.
Okay. So that goes to show sometimes even we do our best as much as we try to review.
No, of course.
I'm not,
This is an honest question because it is
Right.
confusing.
it is
to
confusing.
not see
I
it
think
per the
I
site.
think that question that you're raising, it's better to be placed in the statement of fact, which clearly indicates that because we are not waiving any of the underlying zoning regulations. So that is one caveat that when we do approve it, that would be there, that we are not amending anything with regards to underlying zoning regulations, just a waiver of the GCL 36.
Right.
And so it has to comply with all the underlying regulations, but it is best placed in the statement of fact where the applicant can say, this is the entirety of the zoning lot, and as part of the underlying zoning, each tax lot must meet the minimum threshold, and the subject lot meets the minimum threshold of the minimum lot area and the proposed floor area. Because this is in the South Special Hillside Preservation District
Mhm.
and the lower density growth management area, your zoning, even though it's one entire zoning lot, each tax lot also should have the minimum square footage and the floor area built on each tax lot should almost be like a standalone zoning lot. So those should be clearly stated in the statement of facts and just indicate that it would meet all the underlying regulations, though I'm not sure whether it meets all the hillside preservation district requirements and if it requires any further approval from city planning.
Okay.
Any other questions or comments?
No,
Okay,
thank you.
Done. So that is the last case.
Okay,
for The public review.
okay, so it's 11:50.
Can I get a 5 minutes?
Yeah, let's get a 10-minute. Let's start at 12 o'clock. How about that?
Oh, okay.
We're at 11:50, so let's just start at 12 o'clock.
Okay.
And then depending upon how the hearing goes, we may take a break at around 1 o'clock or 1:30 for lunch.
Madam Chair, I sent you an email. I didn't send it to all of the commissioners, just letting you know.
Ms. Matias, I'm sorry, your microphone is off. I'm not sure if you're,
Microphone is on.
okay.
I'm turning it off. Yes.
Huh?
Here. Yes.
Yes,
On break?
yeah, we are on break.
I said to me, must appear.
Who?
We are ready.
Live? Yes, go. Good afternoon. This is the Board of Standards and Appeals public hearing for July 10th, 2023. We'll begin with the SOC calendar, continuing hearing items. Item number 22. 31953 BZ, 1135 East 222nd Street, the Bronx. Let's just see if he's in the room.
All right. Either we are looking for Mr. Consuegra and or Mr. Majid El Jamal.
I do not see the Consagrea, and I don't see Mr. Jamal. I see a 929 number and I'm nothing else. The 929 number that ends in 768 is a party to this action of 31953 BZ, 1135 East 222nd Street, the Bronx. Can you join us? If not, please join us when your case is called. Oh, the community board person is here, George Torres also. Please unmute yourself, sir or madam. The 929-768, if you are a party to this, if you're the owner or the applicants only right now. Can you unmute? The owner or the applicant? Or his attorney? Can we allow in? I'm not a host.
They're in.
They're in.
Phone number ending in 768. If you could please identify yourself for the record.
Hello? Can you please identify yourself? If you're the owner, applicants or attorney for the property. Maybe he's. I don't know.
Just wait for another couple of minutes.
Okay. We did receive an email from the attorney. Can I
Wanna
put
read-
that into the record?
Yeah.
Yeah, I do. Let me do that while we are waiting. At the end of our review session, the board was notified of the most recent correspondence that we received from Mr. Consuegra regarding today's agenda, and we had asked the applicant to appear at today's hearing. We received a letter, an email precisely today at 11:20 a.m. stating from Mr. Consuegra, can we please move 319-53-BZ to tomorrow? I've been unable to get a hold of my client and I'm stuck in traffic from an accident outside Tulsa, Oklahoma and cannot join a Zoom call. Our response was that we are not rescheduling it to tomorrow. It is going to be heard. This has been on the schedule and the applicant was notified from the agenda was sent out on July 5th. So the applicant has been on notice since July 5th regarding the hearing. Just give me. And prior to that also, when we actually schedule these hearings, the applicants are notified right then and there. So at least it's been over a month. This should have been on both Mr. Consuegra's radar and his client's radar. So I'm not at all inclined to change the hearing to tomorrow. And I'm willing to wait for a little bit longer, but this is it. Yes, Commissioner Sheta.
Thank you, Chair. I just want to clarify. I'm not in favor of rescheduling, and the reason I acknowledge that the applicant, the attorney, is saying that he got an accident, but it sounds like from the email that the reason for the postponement from today until tomorrow is not the accident. It's actually the reason that he is not able to get hold of his client, which is for me is business-wise, it's a disaster. It sounds like that the applicant, the owner of this facility is totally ignoring the board. That's crystal clear from what is happening today and what happened before. So I would be in favor, like I said, of closing this, put it for a vote on the upcoming hearing. And if there is no serious, and I mean serious actions taken, we should vote on this and it's up to them. But I don't think we should be waiting any further after this kind of behavior.
Council has his hand up, has her hand up.
Yes, is this,
Yours up.
oh,
Council Sullivan.
I just wanted to ask if the board would like to second call this case for today. We could put it at the end of the calendar for today and then try again.
At the very least, we should hear from the community. board.
There are people in the room waiting.
yeah, we want to hear it from the community board. I think there are people who want to testify, so I would like to hear them. We can, I mean, this hearing is not going to go very long. We have a very brief agenda for today, so at most maybe an hour later. But it seems, as Commissioner Shetta pointed out, the applicant is not able to locate his client. And I don't see how in an hour that is going to materialize, since there seems to be a complete disconnect between the client, rightfully or wrongfully, or purposely, between the client and its legal counsel. Vice Chair Shibata, did you
Well,
have to say
yeah,
anything?
sure. Yeah. It's been over 8 months that we've requested he contact this attorney to contact his client. And this is both a bit distressing and frankly disrespectful, but it's far more than that, because this case has been monitored for 2 years prior to filing, because of the outcry from the community and from the congressman. In December, we reached out to council and we requested them to touch base with the owner. Now, I don't know if this was the first request, but I know that there were many requests since then. To receive an email at this hour saying that I haven't spoken to my client. I'm not sure how much more leeway we want to give if the first 8 months weren't enough. I could speak to if the chair would prefer, I reserve till we close or to make comments with regard to this type of behavior as an attorney, or if you want me to make those comments now.
Why don't we let the public
Sure.
speak, and then you can
Very well.
make your thoughts clear
Thank you.
at that point, based on what the community also says.
Sure.
Okay,
Thanks.
so you want to go to the public?
Yeah, let's just go to the public.
Okay, the case we're currently discussing is 31953 BZ, 1135 East 222nd Street, the Bronx. Should you wish to discuss, dial 646-558-8656 or our toll-free number 888-475-4499. You will enter the webinar ID number as 816-3044-2359 and press the pound sign. At the next prompt, you will press the pound sign only. Once you're permitted in, you will press *9 to raise your hand to speak. And the next prompt, you will press *6 to unmute to be able to speak if you're calling in on the phone. If you are in the Zoom room already and wish to participate, please raise your Zoom hand, which is the little hand at the bottom of your screen. Once you're permitted in, you will have 3 minutes in which to discuss.
Great.
Would we have?
We have, I don't know, the person who is the last 6 digits, the last 3 digits of its phone, 768. You want me unmute whoever that is? Can you unmute to speak and identify yourself? And then we also have George Torres from the community board.
Let's take George Torres.
Okay.
He's the district manager, right?
Yeah.
Okay.
Mr. Torres, can you unmute, sir? Oh, the other one unmuted also. I don't know who that one is. Can you hear us? Whoever is on 929, you just unmuted, 768.
Yes,
Hello, can we help you? Can you state your name?
yes, yeah, this is registered architect James Chang, for 4645 Casino Boulevard.
No, that's, sir, I'm sorry, the case has not been called yet. So if you would go
Okay,
to the waiting room and call back in when you hear that case called, okay? Okay, thank you. Okay, Mr. Torres? Timer. Can someone let Mr. Torres in? Mr. Torres, can you unmute, please? Why is this like that? Why are we not getting it? Mr. Torres? Can you unmute? Can you hear me? Are we having an issue with people being admitted?
Mr. Torres is in the room.
Okay, so, you know. Mr. Torres, can you unmute? I don't know. Should we wait or?
Okay. I think if Mr. Torres is having difficulty connecting, maybe he can, in the interest of time, maybe he can submit a letter.
The community board has already submitted online.
If there's
There's
anything that they
anything
want to,
additional,
anything additional that they want to add, they can do that.
Okay,
He's muted.
I know he's muted, but he's not unmuting or anything. I don't know. Not letting him in. I'm not a host, so I don't know.
Okay.
Shall we go to?
I just promoted Mr. Torres to panelist.
Okay, Mr. Torres? You join as panelist, sir?
Okay. All right, we need to move on.
Yeah, I'm sorry. We're going to move on to the next case.
But before we do, I want to make a motion to close.
Okay, I'm sorry.
And the reason for making this motion to close is that we have not received any submission from the applicant. The applicant failed to respond on what it promised to deliver, which was correcting the wrongs, revising the plans, providing a topographic survey, and none of those were provided. So this has been an ongoing issue with this site. So I'm going to make a motion to close, and I would like our council to send a dismissal warning letter to the property owner and also to the property owner's counsel, legal counsel. It really saddens me to come to this point and have to close it, but I really don't have any choice. It seems I've not been given any option.
Maybe that's why we gotta get them to respond.
That's not the way it should be played. This is not the way the game is played. If you're calling it a game, this is not the way to do it. This shows lack of professionalism.
It does.
Respect for the.
And lot of respect and lack of respect for the board and the team. It's not acceptable. Okay, make a motion to close. Anybody has anything to state?
I'll make a statement.
Okay.
As an attorney, you have an obligation to make yourself competent in any matter you take on. We've had countless new applicants appear before the board, and with the help of our project managers, those applications have been successful. But the BSA cannot help an applicant who has taken such a flippant approach to prosecution of a variance that is catastrophically not in compliance. Honestly, do not understand what is happening here. If the owner is not in contact with the attorney, how can the attorney provide proper representation? At that point, the attorney should take leave from the matter as there is a breakdown. Or is it the case that the attorney is not making substantial efforts to communicate with his client? In any event, both this matter and the community are being severely neglected. This is not behavior becoming of anyone representing themselves or a client before the BSA. I have nothing further to say on this.
Thank you. All right, let's do the roll call.
On the motion to close, Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
And we're leaving the
We are
open
leaving the record
Yeah,
open.
for a
Should-
submission.
Yes, we're leaving the record open. Should the applicant choose to submit anything, they do have that opportunity to do so.
Okay. Item number
Thank you, Vice Chair.
23, 91559 BZ, 5912 Fresh Pond Road, Queens.
Okay, I
This is
think
Mr.
this
Ash.
is Mr. Ash, Daniel Ash.
Hi, are you the only one attending, Mr. Ash?
Yes, I am.
Okay, please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Please state your name officially for the record and proceed.
Daniel Ash.
Okay.
Go
You
ahead,
heard the
Mr.
board's
Ash.
comments?
Yes, I heard the board's comments. Thank you for acknowledging the work that we had done previously. There were two items left to discuss from what you had mentioned. One was in regards to doing the shielding of the lighting, which is something that we do agree will be done. The reason that I listed it as an item to be done together with the construction project is that it would save us time on mobilization, having to have the contractor go out twice, since we already have a major project for the canopy that will be done. And shielding the lights could be something that they do at the same time. If we had to do it beforehand, it's not the worst thing in the world, but it would cost the dealer more money to have them mobilize additional time for that.
Okay.
And the second comment that you had brought up during the preliminary discussions was with regards to the people who park on the street and putting up street trees. And we did think about it. We talked about it. We got some pricing. It's going to cost roughly $25,000 per tree to put in. We have to get approval from the Parks Department. Yes.
Mr. Ash, I think the beauty of this program is it's the city who puts the tree.
I don't think you could request the city to do it for your property. You can voluntarily put in street
No?
trees.
I thought you put in a request and the city evaluates and then puts in the based on the compliancy and the site condition.
In my experience, you file your application with DPR, Department of Parks and Rec, and they will review it, give you comments and approve it. And it is the owner's responsibility to then install that pursuant to the approved plans.
I see.
Yes, that is correct.
Well, I think it is your call. It's either putting in whatever, how much did you say it would cost?
They think about 25,000 per tree, and we need at least 2, maybe 3 along to make a difference on that sidewalk.
It's a business call because it's either costing that or fixing the sidewalk every now and then and getting violation tickets for having sidewalks in poor condition and a liability issue if somebody trips and falls. So that's completely your call as to how you think you should advise your client. I would say start with at least one tree in one location. And I 25,000 sounds very steep. I don't think it is that steep.
Well, you're breaking the concrete, you're putting in the bed, the planting, and the tree itself.
Right, but you're also hiring a contractor to do a lot of the work within your site. So if you coordinate it, it may not be a separate cost associated with that. Just think
Could-
about
A
it.
little bit, yes.
Just think about it. I know you're looking at the short term, but in the
Mhm.
long term, it will do you better because you don't have to worry about the sidewalk constantly being torn apart by vehicles parking on the sidewalk.
I think we discussed with the owner and what we're gonna try to do, we don't know how yet to get the city to possibly put up no parking signs along that area to keep cars from parking there.
You're
So
fighting against the community board in that case.
we'll make some phone calls to see if that's something that DOT wants to look into and then let them make the call on what they think is necessary for that.
We made those recommendations because we think it is the best way to go about it, but and I want it on record that this board did make that recommendation and that the applicant felt that there is an alternative. And so should the future board consider that whatever alternatives you have proposed fails, then this is something they can hang back on. I want that on record.
That's fair.
Okay, any questions or comments for Mr.? I cannot think of any, as I'm talking, I'm trying to think, are there any simpler solutions? I don't know. I mean, it's not even a great place for somebody to sit by the roadside, by the sidewalk. But if you put a tree, someone would. Anyway, okay. So I am sympathetic towards your issue of trying to have one contractor do all the work. And I would put that as a condition of the shielding part of it. But I have to say, I did not see the complete lumen analysis, which factors in the canopy. And this is where I think I have a question for the board. Did we in the past, if there's a proposed canopy, do we look for the projected lumen analysis of that?
Usually the entire site is done as one unit. They
Okay.
add all the lighting units and then they run the software and to get us the.
Okay, so it can be done.
It's doable, but I mean, if the canopy is far enough from the fences and the property lines, it's not anticipated that's gonna be, the
Just want to look at
impact
the
is
plan
gonna be
if it
significant.
is.
Yeah, that's what I was gonna say. It's about 70 feet from the property line.
Ah, okay, so then it's not really going to impact.
Especially canopy lights are kind of like directed like
Okay,
down, and there is like the canopy ceiling itself acts as a shield.
It's a straight directional down lighting.
okay, all right, okay. Okay, so I'm okay with what you have stated. Thank you, Commissioner Sheta. Let's go to the public then, if there aren't any questions for, okay, that's okay.
The case we are currently discussing is 91559 BZ, 5912 Fresh Pond Road, Queens. Should you wish to discuss, please dial in 646-558-8656 or our toll-free number, which is 888-475-4499. At the prompt, you will enter the webinar ID number as 816-3044-2359 and the pound sign. At the next prompt, you will press the pound sign only.
Yeah.
At the next prompt, you will press *9 to raise your hand, *6 to unmute to be able to speak if you're calling in on the phone. And if you're in the Zoom room already and wish to discuss, please raise your Zoom hand. Once you're permitted in, you will have 3 minutes in which to discuss. Oops, sorry.
Sorry, I was corresponding between my general counsel. So you don't need to make any changes to the plan, but I would like you to provide a letter stating what you have stated with regards to the lumen, providing the shield, that it would be done at the time of the canopy. And what's your anticipated time of getting the canopy done?
After we get the approval from you, we'll go to the building department where it'll probably take another 2 months to get approval. Then we can bid it out to contractors. At that point, you're talking about the winter, so probably in the spring, this will be done.
Okay. Spring 2024. Okay. And I would say any of the other improvements, the trash enclosure, all of those also would be done by spring.
Yes.
Okay. And also provide a letter that the recommendation that the board had made with regards to street tree as an alternative and the alternatives that you're proposing and how you would carry that forth.
Okay.
Okay. So I want to make a motion to close if it's everybody's okay with it. Okay, everybody's nodding in agreement, so close.
Motion to close, Chair
Yeah.
Shanda. Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Oh, I didn't say aye. I said
Oh,
aye.
sorry, again, I'm recalling it. Chair, the vote, the motion to close, Chair Shanda.
I think everybody else said.
Okay,
Yeah.
sorry.
Can we do a second call of the Eastchester case?
Do you want to do it now or at the end of the day? Now? You want to do
Uh,
it now?
Let's do it now.
Okay.
Yeah, I'm
So
sorry.
I am recalling, ladies and gentlemen, item number 22, 31953 BZ, 1135 East 222nd Street, the Bronx, also known as 3651 Eastchester Road, the Bronx.
The reason for second calling it, I want to be very clear on the record. The reason for our closing is for the lack of prosecution from the applicants and especially that the applicant has been able to send us an email. He had therefore internet connectivity, therefore he is on the grid. And if he is on the grid, then he can call in. And he chose not to, regardless, despite us notifying him and telling him regarding the hearing. So regardless, it's irrelevant because his appearance would have been useless as he did not speak to his client. So there is nothing of value he could have offered. So I just kind of wanted to have that also on the record is that he was, he chose not to, given every facility that he was availing himself of to notify us why he could not attend the hearing, but he could have.
We're talking about the attorney, right?
Yeah.
Yes.
Yeah, that the guy was candid. He said he's stuck in traffic. From his language, it seems like he's willing to attend. But his issue is not from the email. If you look at it, his issue is not he's stuck in traffic. His issue is he didn't get in touch with the client.
At a minimum,
It's awfully inappropriate
Right.
because at the very least, you come in, you appear. You call in, you appear and you say, hey, can I get an adjournment? And we've often done that.
But
We've
can
often
I-
put it on the next day. That didn't
I
happen.
don't know if I'm allowed to say this, but can I say this, that his prior email today was pictures from his client. So how can you then say you haven't been able to get in touch with your client?
right.
Isn't that disingenuous?
That's a very good point.
Yep.
We received these photographs, so that means there has been some communication. So
Somebody
the
took the
right hand
pictures.
does not know what the left hand is doing.
General counsel, I'm sorry, did I oversee?
Thank you. Yeah, I'd just like to state.
Overstep my boundaries there, sir?
No, you,
Actually, we didn't open, right? I would close, so We closed it.
We need to reopen?
Sorry.
Okay,
thank
sorry,
you.
we need
Just
to
realized
reopen.
it.
Open. We're not discussing the merits of the application, and I'd just like to recapitulate what the board is stating and then reopening to state. This applicant has seemingly failed to prosecute this application both before the board and before staff. Staff has tirelessly worked with this applicant to produce a responsive submission that has not been made to date. In lieu of a request for an adjournment to make a responsive submission, none was made. Instead, the applicant failed to even appear at today's hearing. The board has closed this, and it will be scheduled for decision, likely for a dismissal for failure to prosecute. There's nothing more to discuss on this application.
Thank you.
Next matter.
Okay. All right. Thank you. Thank you, General Counsel, and thank you, Ms. Matias, for that clarification.
All right, the next item is item number 24, 82067 BZ, 41 Barker Street, Staten Island.
Hi, just me.
Just you, Ms. Folder? Okay, raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do. Elise Bolader from Eric Polanic PC. Thank you so much. We heard your comments this morning and I spoke with the client about the operational plan. He has since he's been in this neighborhood for many decades, he has a deep relationship with his clients. And so most of the time, unless there's an emergency, he schedules with his clients, and that's why he can control the number of cars on the site. I can add that to the statement of facts. And he feels confident that he can do that. He said he scheduled 3 for next week, even this morning. And also on Saturdays, taking his neighbors into account. Sometimes someone comes to work there, but nobody drops off cars on Saturdays, and it's closed on Sundays. So on the weekends, there's very limited work done, so neighbors cannot be bothered by the automotive service station.
Okay. Okay. Yeah, if you could just put a cover letter.
Mhm.
Good. Any other questions or comments for Ms. Bolader? Okay, let's go to the public then.
Okay, the case that we're currently discussing is 82067 BZ, 41 Barker Street, Staten Island. Should you wish to discuss, dial 646-558-8656 or 888-475-4499, which is our toll-free number. You will enter webinar ID number 816-3044-2359 and press the pound sign. At the next prompt, you will press the pound sign only. Once you're permitted in, you will press *9 to raise your hand, *6 to unmute if you are calling in on the phone and able to speak. And if you are in the Zoom room already, please raise your Zoom hand, which is the little hand at the bottom of your screen. Once you are acknowledged, you will have 3 minutes in which to discuss. It's raising their hands.
Right.
It's the clock to go.
Okay.
Not yet.
Okay. All right, make a motion to close. Is everybody okay with that? Okay.
Chair Shonda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
We'll try to schedule it as.
Yeah, no problem. And we'll make sure our submission is in by whenever the submission.
Next item is 1122.
Thank you.
I'm sorry.
Go ahead.
I apologize, Madam Chair. 112281BZ 10414 Astoria Boulevard, Queens. Let me swear you in again. Raise your right.
We should have the counsel for Newcastle, Michael, I screwed up his last name. sorry.
Kayam,
Yeah, yeah.
okay,
I know how to spell it, but I don't know.
Kayam. Please join us as panelists, sir. And unmute. Thank you. Can you unmute?
Yes, can you hear me?
Yep.
Raise your right hands, please. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Yes.
Okay, proceed, Ms. Fullader.
Elise Fullader from Eric Palatnik PC. I'm here with the general counsel from Newcastle, Michael, and I think I'm going to mostly turn it over to him to discuss what he would like to do with the mezzanine, and we can have a conversation and then we can decide what to do going forward. Michael.
Okay. Yeah, so thank you again, everyone, for your time today. I was on the call earlier, so I did hear your comments regarding the mezzanine. So I guess to sum it all up, when we bought the building, that mezzanine was already there. We don't need it for our operations. We figured taking away the stairs would just kind of be, the easiest solution, save costs in terms of actually, removing the floor. And also, I think just having the mezzanine there could be helpful, or could have been helpful for maintenance purposes in terms of accessing lights or the ceiling. But at the end of the day, if it needs to be removed, we'd rather remove it than, amend the application and try and, have it remain. That's not a problem. My request would be that, we're given some type of stipulation or condition that our variance is approved, and we're given, let's say, a year to have it removed. Just because operationally right now, removing it in the middle of the business in our busy season would be a massive inconvenience and interference at the warehouse. And that's basically my request.
Thank you, Michael.
That's fair. So you said about a year you would need to remove it.
Yeah, I think that would give us kind of the flexibility, because we would have to empty out the warehouse, probably close it down for a day or a few days. So that would give us time to find a gap during the slow season when we could say, all right, let's attack it this week and get it done.
Is that because you have I'm sorry, Chair, please?
Go ahead, Commissioner.
Yeah, this is
Shetty.
Commissioner Shredder. Is that because you have a material stored there, or this is because of the maneuverability during the removal of that mezzanine would conflict with the operations within the space?
We have absolutely nothing stored up there. It's empty. We don't need it for our operations, like to store or put any product. It's just a shell space. So it's more so the actual work of removing it would be an inconvenience to the active warehouse going on. So we would, and right now is busy season in terms of construction. So we would just need to find a gap week when things kind of slow down to actually do the work without impacting, our business that week or those few days.
I think I've been to that site, and the way the site is, you have like an internal, like a circulation of goods being moved around. It's like a U-shaped thing. And so people are constantly moving in and out of that facility. And so removing that shed would require that site is secured clear of anybody so that nobody gets injured. So I completely can understand the need to have to do that work when you're not at the busy season. I can appreciate that reason. So
I would be fine with the condition that the will submit within a year photos for the removal of the mezzanine.
okay. Well, we can put that as a condition. Is this I just want to go back. This is an extension of term and time to obtain CO. So prior to obtaining the CO, this should be removed. That's the way I would put it.
That would be ideal.
You have a year to to obtain a CO.
Yeah,
That's
fair.
the way I would tie the two together.
That's fair.
Is that acceptable?
I would request if that's the case, if we could just make the stipulation or the condition. Have the mezzanine floor removed and submission of photos, however you guys like it, prior to the application for the C of O. This way, you know, it kind of just, if for whatever reason that project ends up being pushed, I guess I just want to tie those two together. I don't want us to have a deadline date on that application, part of it based upon the mezzanine, if that makes sense. I'd rather have the mezzanine tied to, we can't actually do our application until that part is submitted, if that makes sense.
Okay. You like our suggestion, and I like that. I think I appreciate your team working with us. This is a good busy season after the pandemic, and we really want the businesses to flourish and help in the construction business and industry. So I appreciate the time crunch that you're facing, and I think this is a reasonable outcome. Any other questions or comments for the applicant's team? Let's go to the public.
The case we are currently discussing is 1122-81BZ, 10514 Astoria Boulevard, Queens. Should you wish to join in discussion, please dial 646-558-8656 or a toll-free number, which is 888-475-4499. At the prompt, you will enter the webinar ID number 816-3044-2359 and the pound sign. At the next prompt, you will press the pound sign only. When you're permitted in, press *9 to raise your hand, *6 to unmute to be able to speak if you're calling in on the phone. And if you're in the Zoom room already and wish to discuss, please raise your Zoom hand, which is the little hand at the bottom of your computer screen. Once you're permitted in, you will have 3 minutes in which to discuss.
There is nothing to submit.
That was my question. Thank you.
The only thing I would, though, just for the record, if you could provide a letter
That's what I was asking.
stating that you will remove the mezzanine within a year's time, because you want to do it when there's a lien period, and this would be done prior to certificate of occupancy.
Oh, okay. I was gonna say the letter stating that it will be removed prior before we go for the certificate of occupancy instead of the year, so that they're not.
Time. They didn't want a time, is what the applicant was saying.
Oh, I didn't hear. You don't want a time limit.
I liked your original suggestion that it needs to be removed prior to when we go for our C of O application. This way.
I understand that.
we have the most flexibility then.
Okay, I understand that, but at the same time, what that ends up doing, the COs don't get obtained.
Okay.
They go on forever, and then we are back again for another extension of time. So I'm willing to give it 2 years
Sure.
For us obtaining a CO, and that should give you plenty of time to remove the mezzanine.
Yes,
You get
And-
two lean periods between the seasons to remove it.
yes. That is-
Ms. Fullader,
and-
you were going to say something? Yes, Ms. Fullader?
I just wanted to tell Michael, not you, because you obviously know this, that usually in the conditions of these types, they usually applications, they put you get a year or 2 years to obtain a C of O. So that's typical. They give you a time on it.
I appreciate it.
Sorry, I just wanted to.
And thank you for your reasonableness.
Okay. All right, so I will make a motion to close, and Ms. Fullader, please provide that letter, just clarify what we agreed on. Yeah.
Motion to close, Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Thank you very much. We will schedule it at the earliest possible.
Understood. Thank you so much.
Thank you.
Item number 26, 8-04 BZ 7815 Parsons Boulevard, Queens. Mr. Dale, please join us. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do so affirm.
Please state your name for the record and proceed.
Good afternoon, Todd Dale for the applicant. I did listen to the review session and heard the board's comments, and I was pleased that the last submission seems to address the majority of issues. With respect to the issues that were raised, we'll be able to submit a follow-up response, but I just want to just quickly address those points now and just to clarify to ensure that we're making or providing the items that the board requests. With respect to the roof, we will definitely work with the architect, and we can provide the distance between the fence, both existing and proposed, and the parapet. And we'll also clarify the roof square footage and include that information both in submission and also in the tech memo revision. With respect to the technical memo, as Ms. Benke noted, comments were issued. Unfortunately, with the holiday, we weren't quite able to get that response submitted to the board, but the team is working on it, and we hope to have a response submitted shortly. We'll clarify with a note on the plans what the fence is at the street level. Just to reaffirm, currently it's a sort of a black wrought iron fence on the synagogue portion of the site, and the school has a nicer black fence, but it's taller. With the proposed enlargement, there will be some changes made to the fence, and I'll just get that information added to the plans. But I think in large part, they want to echo the existing fence, but just make it a more seamless transition between the two portions of the property. And then finally, I just wanted to get a little clarification. Chair, you noted that one of the noise notes wasn't clear on the plans you had received. And I just wanted to confirm which plan that was, because on sheet A-105, which is the roof plan, at least on the version of the plan we have, it clearly says in the middle, no music or amplification of sound permitted on roof. I'm not sure if that's the note to which you're referring, or perhaps the version of plans you have, something changed in the PDF, but I just want to, how's this? Short answer, we'll make the notes clear as possible, but currently on the plans, I see that note is clear. So I just wanted to make sure we were addressing it.
Yes, when I want to see the drawings, I cannot find it, of course.
Okay.
Just give me a second. It was.
So if you look at A-105, which is the proposed roof and bulkhead plan, there is a note directly under the vestibule, the blue in the center. It says note, no music or amplification of sound permitted on roof. I don't know if you want to have that moved or highlighted, or we can, perhaps put a square around it or move it outside the actual roof area, but it is there.
Okay. I wasn't able, so maybe something is wrong with my PDF because I was not able to see it. There was an overlap of the text. Actually, there were a couple of other drawings where in one page there were 4 or 5 plans that were shown. Maybe that's the one.
It's that Adobe thing that you use.
Yeah.
I can share my screen to show you how it looks on my screen.
Oh, I think I know. It's on Z102.
Z102. All right, let me go to that.
5. It's the proposed roof bulkhead. That's where the notes are not at all clear.
Got it. So what they did, I understand what they did there is they basically superimposed, and they probably should remove the layer behind so that's not clear.
Yeah, because this is the zoning page. So you really, I think
Okay.
the information also.
Got it. I can have them remove that layer.
Okay.
Now I understand. All right, remove that there. Okay. So that's not a problem. So those changes, which are primarily plan oriented, should be very quick for us to make, and we can get the plan submitted hopefully very shortly.
It's kind of sad that you're removing the wrought iron fence and replacing it with the existing fence. I like the.
I'm not, let me clarify. I don't know. I don't think that is the plan. I want to get confirmation from the architect. I think they want to keep the wrought iron fence on what would be the southern portion of the property. You know, currently there was the taller fence that's by the existing play area. You know, because mostly the children were out there playing and they didn't want to have a ball fly into the street. That fence currently curves around and actually creates a separation at the front. But with it becoming one combined property, I think they'll be able to remove the separation between the two. And I think they should be able to maintain the lower fence on the southern part of the property, but would still want to maintain the larger fence where that front area is, just to.
Okay.
So what I'll do, the short answer is we'll add notes clarifying the existing fence and the proposed fence, and you know, provide details for it. But I agree with you. I think it would be ideal to keep the fence on the southern portion of the property as is.
Yeah, great. And you don't have any kids playing on that side. So.
Exactly. And there's the landscaping is proposed to be maintained. So if you're going to have the landscaping, show it off.
Right. That's great. And I appreciate that. Thank you.
Okay. So I'll get that clarified there.
Yeah.
Sure.
Any other questions or comments for Mr. Dale? Let's go to the public then. And
Okay, the case that we're currently discussing is 8-04BZ 7815 Parsons Boulevard, Queens. Should you wish to participate in this conversation, please dial 646-558-8656, or toll-free number is 888-475-4499. At the prompt, you will enter the webinar ID number 816-3044-2359 and press the pound sign. At the next prompt, you will press the pound sign only. Once permitted, and you will press *9 to raise your hand, *6 to unmute to be able to speak if you're calling in on the phone. And if you are in the Zoom room, please raise your Zoom hand, which is the little hand at the bottom of your screen. Once you're permitted in, you will have 3 minutes in which to discuss.
Mr. Dale, I did, the question regarding the ADA accessibility. I hope I'm clear. I wasn't questioning the elevator's ability to be ADA accessible. It was more of the building being accessible from the grade. And the existing building as it stands today, it seems is not, because you have to take set of stairs to go to the only elevator that is located at the corner.
Okay.
So I wanted to know if that is going to be rectified with the new vestibule that is going to be created, and that it is going to be completely accessible, ADA accessible entrance.
Sure. To clarify, it will be accessible. Let me find I think the best way, I'm trying to see what the best line is. I think it's sheet A-101. The new blue connecting area, there's a new vestibule and a door, and it's indicated with the ADA access symbol, the entrance exit. So there will be a direct access from the front that goes directly to the new elevator. And then because it is on a bit of a slope, it's also indicated in the center of the building, the slope, there's a slight ramp or slope that will transition between the floors. So hopefully that sheet clarifies that it will 100% be ADA accessible.
Okay. Yes, I see that. It just wasn't clear if there are any steps at that entrance. Anyway.
No steps. Okay.
Okay, thank you. So you need to submit the revised plans with the dimensions provided and the square footage of the play area. And the clarifying the notes regarding the fence material. And I think that should be.
And we also are going to submit the technical memorandum update in response to the questions that were issued. We should be able to submit both shortly. I would just say that I know the board is not able to close applications when there is open seeker, but I'm not sure if the board were otherwise satisfied if they consider closing with the technical memorandum. And I'm not sure where that falls in the policy and whether it's possible to close a hearing.
The technical memorandum is more in response to the prior secra, Ms. Benke. It doesn't speak to the findings. It's more to in response to the environmental review that was done.
Correct. Excuse me.
Okay. So let me ask the board members. I believe the applicant has met the findings. Is everybody in agreement on that, or?
Yes, it seems like based on the applicant's claim that the student population will only grow by 5 students from 425 to 430, that the impacts would be de minimis and don't trigger any of these studies. So I feel comfortable with that.
Okay, good. So I think based on I'm comfortable closing it, but the record will remain open. And we, of course, cannot vote out until all the environmental related comments have been responded to appropriately and signed off.
Understood. And we'll get that submitted as quickly as we can.
So how much time do you think you would need?
I would say that I would expect we could get the plans in a week. The memorandum I know is in progress. How's this? We can be flexible with the board's calendar, but I believe conservatively we could submit everything within 2 weeks and then an appropriate, calendar date based on that.
I never got to ask you, when do you plan to start the construction of the new wing?
To be honest, I think a lot of it depends on when the approval happens and when the DOB review can happen. My answer at this point in discussion with the school is as soon as possible. But other than that, I can't fully estimate, because this is just the one portion of the project, and it's really the Department of Buildings review that's going to probably take a little bit longer.
No, generally schools work backwards from, like, this is my starting date, academic year, and I need certain information by such time. I mean, it's not opening. Definitely need the construction times at least a year from now.
Yeah, I would say at least. I mean, I can ask, and if that information is available in estimate, and I can conclude that in the cover letter of our response.
That would be helpful.
Sure. Estimated date of start. Okay.
2 weeks to submit, though.
Sure.
Okay.
Yes, I think that's a good conservative estimate.
Okay, thank you, Mr. Dale.
Thank you.
Motion to close.
Chair Shonda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Thank you.
New cases on the SOC calendar, special order calendar. Item number 2711-93 BZ 4645 Casino Boulevard, Queens. Carlo, you have your hand, the executive director as a hand up.
Oh, sorry. Yes, Mr. Costanza.
No, I'll allow the applicant to come in. I just wanted to clarify something that was discussed this morning in the review session and perhaps while the applicant's with us.
Yeah, what?
What? I'm sorry.
I didn't hear the last part.
Costanza, I'm here if you were waiting for me.
Okay. Okay, Mr. Noriega.
Sure, and I'm just waiting to see, I should be joined shortly by the architect James Chang, who should be dialing in. He hasn't already.
Yeah, James Chan.
He's ready. Yes.
I don't see Mr. Chin in yet.
Well, I don't want to take up too much of the board's time. If you want to swear me in, we can swear him in if he joins.
Okay. Please raise your right hand, Mr. Noriega. And it's nice to see you.
It's nice to see you.
Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do. And it looks like James just joined. James, is that you?
The 768 telephone number? Last three digits, 768? It's the gentleman who called earlier, 929. Are you the architect, sir, that called earlier? Could you unmute, please, so I can swear you in? Mr. Chin?
Yes,
You are Mr.
this is
Chin?
James Chang.
Okay.
Yes,
Let me swear you in, sir. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
oh, yes,
Okay,
yes, I do.
okay, thank you. Mr. Noriega, please
Thanks.
proceed.
Good afternoon, Madam Chair Shonda and the chair members. Mr. Costanza, when I joined, it sounded like you had something you want to start with. Did you want me to jump in or did you want to take it away?
Yeah, no, Ms. Noriega. So this morning, I know that the board members had made a suggestion that the record or the history of the cycle back to 93, or at least the conditions, but then I kind of spoke quickly without having reviewed the record. So I just wanted to clarify. So this is a pre-1961 application under subject to 1141. So I would only suggest for the record and to clarify something that in your statement, if you can bring it back to, I believe the initial BSA calendar number on this was 788-57BZ. So that should be referenced because again, this is under the authority, the board's given the authority under 1141. And I've also suggested to council that I believe in one of the subsequent approvals of the board's resolutions after the 93 change of use under 11413, one of the resolutions referenced 7221, which threw me off. So that's not your fault, but I just wanted to be clear that I kind of asked the question, but this is a pre-1961 application, and 93 only reflected that the change of use was filed under 11413, and I believe at that time it was an unusual board practice to request a new BZ number under those types of amendments. So that's what I researched.
Perfect. Thank you for that, Mr. Costanza. And yes, I may actually reach out to you and clarify some of those things with the board staff as well. But yes, let me introduce myself, by the way. My name is Frank Noriega. I'm here from Belkin, Bird and Goldman on behalf of the applicant, Casena Group LLC, the owner of the property. And yes, Mr. Costanza is correct that the history of this is it goes back and forth in some of the resolutions, but the general issue is that this was originally an automotive service repair site back in the 50s. And prior to the modern 1961 zoning, this had a variance, pre-1961 variance to operate as such. And then when the new BZ number was issued in 1993, the application was for a change of use. But since then in 1961, the property has changed and now modern zoning has taken effect. And the front half of this property along Casena Boulevard has now been zoned for commercial, which allows for things like use group 6 restaurants. So the use itself is predominantly as of right, but because the zoning lot as a whole does have a portion that is not within the commercial use group, that is where the board still has control over this, and it needed to approve this for a change of use from the automotive use group to the 30 rear feet of restaurant towards the back of the property, as well as the parking lot. And I listened to the board's review this morning, and I absolutely agree. We need to go back and look at all the conditions that apply to that, and we can certainly go back to 94 as well as look at what the issues were in the 57 grant. But I think that alone will address a lot of the issues that were raised concerning the rear of the property, the parking, the screening of the garbage, the locations, and we can certainly address all of those items with that. In addition, also look at what the conditions were regarding the fence that goes around the property, if it's our fence, if it's a masonry wall, or if we're relying on the neighbor's fencing. As far as the delay into that, we'll have to discuss this more with the property owner, also in conjunction with the restaurant owner to see what was going on with this. I know that there has been substantial work done to this property, but why a new certificate of occupancy hasn't been generated is not that. I'm not aware of that at this time. I know the architect James Chang, who is on the call with us, can touch a little bit. I know he's been in contact with DOB and has since superseded the prior filing to allow us to move forward and obtain a certificate of occupancy. And I'll just turn it over to him just really quickly to say that kind of his discussion with the Department of Buildings and where we are with that. James, you mind touching on that really quickly?
Oh, yes. I got involved with this case since October 2021. And after a couple of months, we filed the superseding application with plans. And that was last March or April back in 2022. And then the plan examiner rejected simply because the client or owner missed the extension of time to obtain the cert of CFO, which expired on June 17, 2015. But I said I have every right to supersede that alteration case job as a new applicant. And then I appealed the case to the Deputy Borough Commissioner Simon Lee, and Simon made the decision to say I approve you as a new superseding applicant, but the DOB will not approve any drawing or your amended plans at this time. Your clients have to work with the attorney and go back to the board. And when the board gave a new extension, so the DOB were having the authority or jurisdiction to approve your superseding plan. So that was then Deputy Borough Commissioner Simon Lee's his stipulation. Yeah.
And yeah, and then subsequent to that, we were involved and brought this case to the board. But most of this is going to take some research on our part and also amending the application to show the documentation to address the board's concerns. But we'd be happy to take any questions from the board if they have anything since we're here at the hearing.
I think you pretty much get the questions that we were asking for, and whatever has been stated by Mr. Chen, those should also be documented, providing a timeline. So you know what you have to submit. I don't have any other questions or comments for Mr. Noriega or Mr. Chen. Anybody does? Okay. Let's go to the public. I would also say, you know, there, as you said, there were a lot of conditions in the prior grant. So as you go through each one of them, you would be able to also help fill in the gaps with regards to all those questions and give us a clearer picture of how the site operates also, because that was another comments that we had.
Absolutely. And a lot of those are going to be ongoing conditions that we will demonstrate. One in particular, I'll have to do some research on is the sidewalk. I don't know if that was actually addressed previously, and I will obviously will respond to that accordingly.
Okay.
For the public? Okay.
Yes.
The case we are currently discussing is 1193 BC, 4645 Kissimmee Boulevard, Queens. Should you wish to discuss, dial 646-558-8656 or toll-free number 888-475-4499. You will enter the webinar ID number 816-3044-2359 and press the pound sign. At the next prompt, you will press the pound sign only. Once you're permitted in, you will press *9 to raise your hand, *6 to unmute to be able to speak. If you're calling in from the phone, and if you're in the Zoom room already, please raise your Zoom hand. Once you're permitted in, you will have 2 minutes in which to discuss. Now he's gone.
Okay. How long will it take, Mr. Noriega, for you to provide comments or submit a response?
James, since you have the most direct contact with everybody, do you have a rough idea of how long you think we need to get an idea of respond to these things, particularly with the rear area, making sure that we can get those photographs and maybe potentially drawings amended if need be? Would 2
think
months be about right?
I think you would need at least a month, if not more.
I think it's safer to say 2 months, just to be safe.
Okay.
Let's plan on
Yes,
that.
I agree with you. Yeah.
All right, 2 months it is.
Perfect.
And
Thank you so much.
This is Carlo Costanza. Please reach out if you have any questions, but I think you were on point on explaining the history here. And again, not to make you do extra work, I think it's pretty clear that this is no longer. So just to clarify the site, the history of the use on the site. And I think it's very important that your narrative should just explain that when the subsequent rezoning occurred, that made the majority of the site conforming, and if not for that remaining portion, you're almost as of right.
Absolutely. We can certainly look into that and we'll address that accordingly.
Yeah, we just want to make sure we capture this into the record for the future so that there's never any confusion.
Sounds good to me.
Thank you.
Thank you.
You know what? Thank you, Mr. Noriega.
Very welcome.
Before we go on to the next case, my vice chair rightfully reminded me, should we go for a lunch break? Everybody's nodding yes. So, okay, we then go for a lunch break. It's 1:20. So we typically give what, how much?
45 minutes.
45 minutes.
Back to 2.
2 o'clock.
Easy.
Let's make it easy. 2
And even
o'clock.
2?
2 o'clock.
2 o'clock? Okay, so we're going to take a lunch break until 2 o'clock.
Thank you.
Okay,
Thank you, everyone.
okay.
Thank you, Mr. Noriega.
I texted Consagrata so. Okay, thank you.
Okay, we are live.
We're live. Okay, make my microphone. Good afternoon. We're back on the record. This is the Board of Standards and Appeals public hearing for July 10th, 2023. We'll continue with the new cases on the special order calendar. Item number 28, 5412 BZ, 6539 102nd Street, Queens.
This would be
Sandy Agnostu. Sandy, can you please join us, please? Miss Agnostu, sorry.
oh, what happened to the person?
Is anyone with you, Miss Agnostu?
Yes, the property owner, Mr. Alex Bangaev.
Edward Bongaeve?
Yes.
Edward, okay. Could you please join us, sir? Join as panelists, please. Yeah, your hand is up. Thank you. I'm not a host, so I can't let you in.
He's raising his hand.
Yeah. Can you video, please? Thank you.
Hello.
Hi, good afternoon.
Good afternoon.
Can you both raise your hands, please? Raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Okay. Ms. Agnostu, you've heard the board's comments today. Can you please respond?
Yes, we did. And in terms of the Department of Buildings filing, an application was filed with DOB now. It's number Q00628683. And that replaced the previous NB application number, which was in the BIS system. And this information is on the second page of the statement of facts. And in terms of the timeline, we estimate approximately 30 to 60 days to obtain the Department of Buildings approval and permits after we receive the BSA extension of time. And once we do receive the permits, we'll commence construction work immediately. So in terms of the entire project and obtaining a certificate of occupancy once it's completed and all the required sign-offs, we estimate approximately 1 year to complete and obtain the C of O.
Okay. And you have all the financing and everything in place, right?
Yes, the property owner does.
Okay. Okay. I think just to be on the safe side, I would say it would take you more than a year because sometimes the TCO approvals of plans and all of that. I would say just build those in to be on the safe side and make it at least 1.5 years.
Okay.
You can just revise the timeline for that. I'm just factoring in the worst case scenarios of situations. That's why.
Yes, we understand, Madam Chair. But the extension of time we are requesting is an additional
2 years. No, you did not state actually how many years your state.
So we would need, yes, I think 2 years.
Yeah. Yeah, your application wasn't clear regarding how many years you needed. So also clarify that in your letter.
Well, what is the most we can request?
I think 4.
4 years?
Yeah.
Is it possible that we don't anticipate requiring 4 years, but
I think it's,
you would like to have the time?
I think it might be best to play safe.
I think that's okay. Since you're allowed, you're going to seek all 4 years, okay?
So 4-year extension.
So we'll clarify that in our letter,
Okay.
which we can provide today or tomorrow at the latest.
Okay.
Along with the corrected, Commissioner Sheta mentioned the typo in paragraph 2. We'll correct that as well.
Okay.
Thank you.
Thank you.
All right. Any other questions or comments? In that case, let's go to the public.
Okay, the case that we are currently discussing is 54-12BZ 6539 102nd Street, Queens. Should you wish to discuss, dial 646-558-8656 or the toll-free number, which is 888-475-4499. You will enter the webinar ID number 816-3044-234-2359 and press the pound sign. At the next prompt, you will press the pound sign only. Once you're permitted in, you will press *9 to raise your hand, *6 to unmute in order to respond on the phone. And if you're in the Zoom room already and wish to discuss this matter, please raise your Zoom hand, which is the little hand at the bottom of your screen. Once you're permitted in, you will have 3 minutes in which to discuss.
Ms. Anagnostou, you said it'll take you a week to make the correction, send the revised information, right?
We can make them today or tomorrow at the latest.
Okay.
Yeah, it's a minor.
Okay. It's a minor thing. I think we can schedule this for July, if not August, for sure. And somebody will get back to you, but do submit it as soon as possible because the July submission date was last week. So please
Okay.
submit as quickly as possible. Okay.
There's no hands.
I'm going to make a motion to close.
Is everyone fine with that?
Yeah, everybody's okay with it.
Okay.
Yeah.
So motion to put Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown. Aye. Commissioner Sheta.
Aye.
Commissioner Yoon.
Aye.
Okay.
Thank you so much.
Thank you.
You. Item number 29 to 1113BZ, 346 Broadway, Manhattan.
Who do we have for this?
We have James Power.
Are you on here?
Okay.
Is it on?
I haven't seen him in a while.
James Power?
Haven't seen him.
I turned it on. like 10 seconds ago.
James, Mr. Power, can you unmute, please, and join us?
Yes.
There you
Yeah.
are. Okay, great. Sorry, I didn't see you. Okay, raise your right hand. Is it, oh, well, first, is anyone joining you, Mr. Power?
Yes, Bill Harvey from the applicant and ownership. Was he on? Bill, are
Okay.
you there?
What's his name?
Bill Harvey.
Bill Harvey.
Yep, he has just raised his hand.
Yeah.
Okay.
Please join us as panelists, Mr. Harvey, so I can swear you in. Thank you.
Why am I not able to?
Takes so long for them.
Yeah, I'm not able to.
You're not a host, right? Neither-
Yeah, I cannot.
Yeah.
I don't think we'll need Bill. I can bring him in separately later if we do, so we can go ahead.
You want to just start, Mr. Power? Is that what you want to
Yeah,
do?
we'll just start and you can.
Okay, raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions? There's
Yes, I
Mr.
do.
Harvey. Wait, before you speak, so let me swear in Mr. Harvey. Put your right hand up, please, sir. Yes. You affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions.
Yes, I do.
Yeah.
Mr. Powers, proceed.
Thank you very much and good afternoon. Jim Power from Kramer 11 on behalf of the applicant. In response to the one question that was raised at review session this morning, we did appear before Community Board 1 and received a unanimous recommendation of support for the application. We can submit that separately into the record if it's not already in the record.
Yeah, that would be helpful. That is missing. Thank you.
This case was-
Any other questions or comments? All right, let's go to the public. We'll keep it short and sweet, Mr. Powers.
Thank you very much.
Good to see you.
Nice to see you too.
Okay, ready? Here we go. The case we're currently discussing is 211-13BZ, 346 Broadway, Manhattan. If you wish to speak on this matter, dial 646-558-8656 or a toll-free number, which is 888-475-4499. You will enter the webinar ID number 816-3044-2359 and press the pound sign. At the next prompt, you will press the pound sign only. Once you're permitted in, you will press *9 to raise your hand, *6 to unmute in order to speak on the phone. And if you're in the Zoom room already, please raise your Zoom hand, which is the little hand at the bottom of your screen. Once you're permitted in, you will have 3 minutes in which to discuss. The list is getting shorter. There we go.
All right. We'll try to put this on for the earliest possible hearing. I don't know if July 24th is possible, but August definitely. But if we can do July, we'll let you know.
Okay, thank you very much.
And please do submit the community board letter as soon as possible.
Yes, we'll do that today. Thank you.
Great, thank you.
Scares me every time it goes.
Okay, I'm going to make a motion to close.
Chair Shonda,
Aye.
Vice Chair Shibata,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Yoon.
Aye.
Okay, thank you.
Thank you very much.
All right,
Okay.
enjoy the summer.
You too. Bye now.
Appeals calendar, continued hearing items, item number 30, 2022-20A through 2022-22A, 724, 726, and 728. Richmond Terrace, Staten Island. Oh, there you are. Okay, good. You pop out.
Mr. Dale?
Mr. Dale, this is an appeals case and you're not required to be sworn in, so please state your name for the record and proceed.
Great. Good afternoon. Todd Dale for the applicant. I did listen to review session and I don't believe there were any outstanding questions from the board.
No, and thank you for making those changes.
Sure.
So let's go to the public.
So the case we are currently discussing is 2022 2022-20A through 2022-22A, 724, 726, and 728 Richmond Terrace, Staten Island. Should you wish to discuss, dial 646-558-8656 or our toll-free number, which is 888-475-4499. At the prompt, you will enter the webinar ID number 816-3044-2359 and press the pound sign. At the next prompt after that, you will press the pound sign only. Once you're permitted in, press *9 to raise your hand in order to speak. Press *6 to unmute if you are calling in on the phone to be able to speak. And if you're in the Zoom room already, please raise your Zoom hand, which is the little hand at the bottom of your computer screen. Once you're permitted, once you are acknowledged, you will have 3 minutes in which to speak. Okay. There's no submission on this one.
No, no submission.
So we can give it this one. Just waiting for the timer to finish, Mr. Dale.
Understood. You need a countdown graphic on your screen.
Well, you know,
Very suspenseful, like a game show.
here we go.
We thought about that.
What's that?
We thought about that countdown thing.
Oh, yes.
All right, I'm going to make a motion to close.
Chair Shonda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
We'll try to schedule it. I think realistically would be August.
Understood. Thank you for your time.
Thank
The next item is 2022-28A through 2022-30A, 1517-19 Bedell Street, Staten Island. What did I do? Miss something.
What happened?
No, the sheet was messed up, sorry. Mr. Vittorio? Mr. and Mrs. Vittorio? Both of you are appearing. You want to join us, Mr. Vittorio? Linda and Ronald.
Hello, can you hear me?
Yes, Mr. Vittorio, I could hear you. Am I not seeing you though? Oh, there you are, Mr. Vittorio. Is Mrs. Vittorio joining you?
Yes, she is.
Yes, I'm also on the call. Yep.
Hi, how are you?
Hi.
You don't have to be sworn in because this is an appeals case. Please state your name for the record, and you've heard the board's comments, and please respond.
Ronald Victorio, RA, applicant on behalf of the property owner.
Linda Smythe Victorio. I'm an attorney counseling the office and the applicant on this matter.
Go ahead. Who wants to start?
I'll start. First, I'd like Madam Chair Shonda, Deputy Director, and the commissioners. I just want to acknowledge and appreciate the postponement on this matter. In moving forward, I have an opening statement regarding this common law vesting. I did hear the comments from the board, and I will address them at the end of the statement. And should you have any other questions or need any other clarity, we will respond. So good afternoon. If the project that is the subject of this appeal had a title, it would be a series of unfortunate events. This property owner purchased an existing one-family residence, intending to demolish that structure in order to construct 3 semi-attached and attached single-family residences in its place, all as of right under the zoning existing at the time. He secured a demolition permit raising the existing single-family residence in accordance therewith, hired an architect to secure approvals for 3 new buildings, hired a contractor to secure permits to build and perform the required excavation and construction to install foundations for those new buildings. That is when the unfortunate circumstances took hold. A large tractor trailer working at a supermarket across the street backed into the completed foundations, damaging the foundations. To make matters worse, there were numerous annoying complaints made to the various city agencies lodged for simply constructing legally allowable attached residence in place of the single-family home. The foundation was declared unsafe and corrective measures were required. This began and would become a laborious and tremendous costly nightmare for the property owner. Miscommunication between several city agencies combined with the subsequent change in zoning would result in stop work orders being incorrectly issued, rescinded, reissued, subsequently rescinded, and ultimately the foundation being improperly infilled by a city agency. All while the property owner had secured permission to continue construction from the DOB Borough Commissioner. When the property owner attempted to resolve the agency's confusion, removal and infilling of the foundations and repair of the foundation, the change in zoning was raised as a block to continue with all construction. The property owner incurred enormous costs in retaining professionals to present their position to all city agencies in an attempt to expose the inconsistencies and present their dilemma and right to continue with the project. Ultimately, the position of the property owner under DOB audit of the application and substantiation of the placement of foundations under the initial permits prior to the date of the zoning change was accepted. A new permit was issued to continue with construction. Foundations were repaired and framing began. Repeated calling and complaints about the site resulted in subsequent stop work orders being issued. When the property owner attempted to secure a new permit, the issue of the zoning change was raised by DOB, taking that position that an appeal would be necessary only to obtain new permits to be issued. Property owner even retained another architect in an attempt to comply with the new zoning, which proved to be infeasible. This property owner followed the rules, took the proper steps, completed the foundation and the framing in accordance with valid permits, yet despite all of that, they were caused to incur enormous expenses, work, and financial loss as a result of the zoning change that occurred during the course of construction. As required under Putman Armark versus Town of Southeast, this property owner clearly acquired vested rights in the non-conforming use by having completed substantial construction and having incurred substantial expense and accordingly with validity issued permits. As can be seen in the documentation regarding the construction completed and the costs incurred, vested rights in the non-conforming use have been established. Putman set forth only 3 factors that should be considered in deciding if somehow those vested rights should not be allowed to be hold, and the enforcement of new zoning upheld. 1 factor is the abandonment of the property. This is definitely not incurred herein. The property owner has continually pursued completion of the construction in accordance to the original zoning in fighting for the property through foreclosure. 2nd factor, the recoupment of financial losses suffered by the property owner. None of the exorbitant costs of this project have been recouped by the property owner, and they continue to suffer losses as time goes by without completion of this project. The 3rd factor is the extent to which the beneficial public health, safety, or welfare would result in the enforcement of the new zoning. As is clear from area maps, the 3 proposed attached new residences would be more in character with the surrounding area than a single-family residence currently allowed under zoning. I want to thank the board and listen to your comments. This is a complicated case, and through all the documentation that was sent to you, the commissioners have a clear view of what happened to this project and the frustration of the building department process and losses to my clients. So I would like to address one of the issues that were raised I believe there was a comment from one of the commissioners that there was a lack of proof of satisfaction of the foundations being in place by DOB. As part of the documents that was submitted, there is a notice of objection special audit that was issued on November 14th, 2007. The building department plan examiner was a Benjamin Bork, PE. The raised objection was on October 27th, the area of construction rezoned from C1-1 to residential R3X, submit proof and permit. Permits issued and foundation was completed prior to the effective date of this amendment or submit BSA approval. That audit was rescinded on 11/27/07. In addition, there was some comment from another commissioner stating that you would have preferred or liked checks of payment. The bank that funded this construction at the time is defunct, no longer available. We've checked with other banks and their policy is they have no requirement to retain these canceled checks for a period of more than 7 years. What we did submit were a substantial number of bills, and most of them being marked paid by various contractors indicating clearing of the property, excavation of the dirt, pouring of concrete of the footings, pouring of the concrete for the walls, and then subsequently, after the zoning change, additional payments for repair of the foundation, excavation of the infilling dirt. So at this point, my position as the architect, now being the architect of record, I was not the original architect of record on this. This has been an exhausting, frustrating process for my client, and they have incurred enormous losses on this project to date. That's the end of my
Yeah,
statement.
I couldn't, the document that you were referring to, Mr. Victorio, dated 11/14/2007 DOB audit, and then the DOB resending that audit. If you can provide that document, because I'm not able to locate it. And I think Commissioner Otley Brown was also looking for it as you were talking. We were not able to locate it.
Okay, I'm sorry you weren't able. I know we sent you a very large package as one lump sum, and there is no problem. I can send that separately to you and update it.
I think by and large, from what you gathered from the commissioners, I think if there was a title and the title that you picked, we all agree it's an unfortunate title to be given to this site, but it has gone through a very torturous process of development, and no property owner should have to undergo this level of frustration. Be that as it may, I think we do have to do our due diligence, and for the record, all this information needs to be provided. Commissioner Otley Brown gave very clear direction. We recognize that you may not have the documents with regards to checks that were submitted, and Commissioner Otley Brown recommended using Marshall and Swift as a way to kind of indicate the expense that would have incurred in building that foundation and till 2005. So just let me finish. I want actually Commissioner Otley Brown to chime in to what I'm saying, just to follow the conversation, and then we'll go to Commissioner Shetta. Anything that you want to add to that?
I just wanted to say that really all you need to concern yourself with is the threshold text change date, which was October 27th, 2005. And that is the date that all of your documentation should be citing. And so you don't need to go to any work that was done after that point, just for the purposes of establishing that you've vested. You should be giving us the substantial work done by that date, substantial money spent by that date, which you will forensically recreate using Marshall and Swift, and then the serious loss based on what was there on that date.
Fair enough. That can be done. I will separate that. I realize and apologize for the lump sum of information and not categorizing it by date.
And the document that you were referring to with regards to establishing that the foundation was there in the absence of a photo, in your cover, when you submit it, submit with a cover letter and state each one of the questions that we had raised and the responses to it and the attached document. So that way we are then specifically looking at the questions and the submission information.
Yeah, that document, Madam Chair, that document was included in the overwhelming large package, but I will separate it out and we'll keep that zoning date change for any further information that's submitted.
Yep.
Thank you. Thank you for the guidance on that.
Commissioner Shetta, you had a question.
Thank you, Chair. Yeah, I just wanted to mention about the photos. During that incident occasion happened, have you taken any pictures or like any some sort of visual to show that the foundations were there? The reason I'm mentioning this, I actually took a dive into my resources, the historic things, and the latest I was able to go is March of 2006. Let me just put that on the screen. It's showing that the foundation is there.
I don't think Mr. Victoria was the architect of record at that time.
I was not the architect of record and came on much, much later. There is something I believe on Google called history of the maps. I don't know how far it goes back. I can also inquire with my client if possibly a foundation location survey may have been performed.
So, Mr. Victoria, Commissioner Shetta is sharing his screen, which is in this database, which has a lot of historic aerials. And in that aerial map, it seems to show that the foundation was laid for
This is not the historic thing. This is a website from the city that we have a subscription to.
Oh.
And you can go with the date. And the latest I was able to, like, if you look at the dates here, you're gonna see that this is from March 2006.
Right.
Before that, it's 2003.
Yeah, it's a 3-year gap. We don't have that 2005 year indicated.
Yeah, it is clear for me that the foundation and the excavation were there in March 2006, which is probably 5 months after the effective date. But if you can, the other side that the chair was talking about is this, it's called historic aerials. I actually tried to look at it, but again, it's 2006 and then 2004. Even if you buy these, they are not going to be helpful.
Yep.
That's why I'm saying if during that incident, you took some pictures.
For insurance purposes or anything.
Yeah, exactly. If somebody stopped by, do your best, see what you can get us, and then we'll take it from there.
I will verify with my client if there's any further photographs, claims to the insurance company, foundation location, stakeout, survey, any other supportive documentation that may assist you in making a decision here.
Thank you. And it doesn't need to show the entire foundation for the 3 houses.
Understood.
Partially, that would be
Actually, they were subsequently installed all at the same time. For building purposes, it's one building with 3 building sections.
Thank you.
Commissioner Otley Brown has a suggestion.
Might you have the supporting packet that you gave to DOB during the special audit? Because for DOB to sign off that, yes, you vested, they had to have seen the proof that the foundations were there.
I will inquire with my client because at that time, she presented that on behalf of her husband, the owner, and went down on that audit and had it rescinded. So I will ask her what documentation she presented to them at the time that allowed the audit to be rescinded.
Okay. All right. Any other suggestions, thoughts?
There was one other question that was raised by one of the commissioners about the value of a new building. And questioning that the cost of $1 million may be a little excessive. Construction costs have gone up tremendously. We have a corner lot, an extreme amount of street frontage, curbs, paving, roadways that have to be done. You have landscaping, street trees that need to be planted because it's located in South Richmond, site trees which need to be planted. I took the number 4,300 square feet and times that what I feel is a fair number in the construction industry of $250 a square foot. And that comes up with approximately $1 million to complete the construction on this building. You have utility services, 3 water mains, three sewer connections, 3 house connections for electric, gas, if we can still get the gas situation installed prior to what the mandate that may come down, not allowing gas to be to the building. So I feel it's an accurate number for the construction of a home.
Can I respond to that? He doesn't need to, you don't need to go with that, like the value of the entire house. You just need to focus on what was done before the effective date and show us the value of that. And this is your serious.
Commissioner, let Commissioner Otley Brown
Actually,
speak to
I
it.
believe what he's trying to show is the comparative loss in value, which is something that we do accept. So what he's basically saying is, if I had to build this new home, he's saying the value is based on the cost. And where I was just questioning the cost that you quoted, saying that, could you give us a reference of what manual you used to establish the cost? Because it seemed like it was hot. But I understood what you were trying to get at. You were saying basically, if I sold this one home, the value of that one home is much less than the value of the 3 homes. If you would.
That is correct, and you grasped that from the very beginning. And I don't have a manual or a standard. I just have, being in the construction industry and being an architect for some 43 years, and used my expertise in that. Our office produces probably 65% of our work is 1 and 2 family commercial construction.
You can also support it with just a quick sales analysis as well, and just say 3 homes that are attached would sell for, let's say, I don't know, 2 million, let's say you would say, but 1 home by itself would sell for 1.4 million. That's a loss of, $600,000. That's all you would need to do to establish your loss in value.
Yeah. Also, Ms. Brown, Commissioner Brown, a 1-family house of that size in that area with the mixed neighborhood would be out of character with the neighborhood. And I don't think you would get the premium on the retail sale of the home that you would possibly in a more 1-family detached residential district.
That would,
So
that absolutely would support your case.
Yep.
Unless there are any other questions, I don't have anything further to say. Just an acknowledgement of the letter from General Counsel, Department of Buildings, acknowledging that both permits were valid and legally and lawfully obtained at the time.
Can you, I had a question, and since I have it on record, and that's regarding the zoning, can you confirm what was the zoning that was in place prior, when you received the building permit? And
Initially, the initial permit and initial approvals were approved under the zone being a C1-1.
no, C1-1 is a commercial overlay. What
Right.
Residential?
You know what? I don't have that information at hand, and I will confirm that for you.
Right, because that's
the overlay over the residential district.
right. And also you need to submit the approved building permit, because that's what you're seeking the reinstatement of.
So you would want the initial permit on all 3 NBs permitting commencement of construction.
Yep.
And is that made part of that first package that Commissioner
I
Sheehan
did
asked?
not, you know what, maybe it's in the void folder, I do not know, but I couldn't locate it in the folder that we all are reviewing. I only have the revised plan, which is a drawing that has been prepared by your office.
In my cover letter in response to additional information that was brought up by Deputy Commissioner Matthias, I did respond 15 Bedell, 17 Bedell, and 19 Bedell The initial permits was secured on 10/12/2005 on all 3 units. I can certainly get you a copy through the DOB system so that you can have those permits as part of the permanent record.
Yeah, and the approved plans.
And a copy of the approved plans, yes.
Okay. All right, so you need to confirm the zoning district.
Zoning district at the time the initial plans were approved.
Mhm.
Yeah.
And that should be also on the DOB drawings.
I will do, yep, not a problem for us to do that.
He does cite the new building application numbers that were reinstated by DOB for the purpose of filing the vesting in his response to questions. I think the file is called Response to Comments Letter dated 6/20/2023.
Correct.
And that would be 15 Bedell Street, 5006 88801, and then 17 Bedell Street, 5006 88794, and 19 Bedell Street, 5006 88785.
That is correct. Any other additional information the commissioners require or any clarity?
I'm just looking at this.
It's page 3.
Yep. Okay. Okay. I think just to, for the record, would be just easy if you can, in your next submission, just put in every question that was asked, and if some of them are even repeats, just state them.
Fine, I will repeat the question and the response to each
Yeah,
issue raised by the commission.
thank you. Okay, any other questions? Okay, does Miss Victorio want to say anything, or we can go to the public then?
No, I just wanted to just also clarify that the property owner satisfied the vesting requirements both in under 11-331 ZR and the common law doctrine. So either of those could be considered as grounds for allowing the permit to be reissued.
Okay. Okay, that's a good point. So was that state?
Isn't time a factor? The filing time for
Time
the
is a factor.
Why? Yeah, so they could only do a comment.
Well, that's why they have the
Right.
comment.
Yeah.
But they did mention it in their statement of facts, which I asked them to revise to address the 3 findings.
Three
under
finding,
common.
right,
So,
okay. Okay, all right, let's go to the public.
okay. So the case that we're currently discussing is 2022-28A through 2022-30A, 1517-19 Bedell Street, Staten Island. Should you wish to discuss, dial 646-558-8656 or a toll-free number 888-475-4499. At the prompt, you will enter the webinar ID number 816-3044-2359 and press the pound sign. At the next prompt, you will press the pound sign only. At the next, what the heck has happened to my screen? At the next prompt, you will press *9 to raise your hand, *6 to unmute in order to speak if you're calling in on the phone. And if you're in the Zoom room already and wish to participate and discuss, please raise your Zoom hand. Once you are recognized, you will have 3 minutes in which to discuss. Mr. Vittorio, how long will it take you to assemble all that information?
I will get in touch with my client I will have to contact a surveyor to verify whether a survey was performed. I can probably return that information and make every effort to complete it within a week.
Okay. I don't think we can schedule this for July. August is possibility. So,
What's the closeout date, Madam Chair?
well, if.
In order to be held on the July,
Pardon?
what would be the submission date for me to get the information to
July
you?
is past. Submission date for July was last week.
Okay,
So August, we have I just want to look at the,
I think it's.
when is this? Oof,
It's 20 days before, isn't it? 2.5 weeks?
I-
3 weeks?
I'm just looking at this calendar. Just give me I don't know why it's the.
I think next week is
Okay, so
July 22nd or something. I think is the-
Yeah,
July 20th. July 20th, I think is the date. Or the August date,
yeah. Is that the submission date?
I think that's the date.
Just looking at it's so slow. I'm sorry, my computer is very slow. Okay, the submission date for August 7th hearing is July 20th. That should give you plenty of time to put together your response.
I thank you. I'm sure we'll be able to complete it by then.
Okay.
Okay.
Okay, so let me ask you a question. Do the commissioners, do you want to close it or do you need to see the information?
Agree. I'm okay with closing it.
I kind of think we need the information. I think some of these are critical information.
It's threshold issue.
These are threshold issues. Okay. All right, unfortunately, we can't close because some of these are threshold issues. So that goes towards the findings. So while we theoretically, I think conceptually, we agree that it is definitely would meet the requirement, but we need the information to back up. So that's why it's in the threshold.
Okay, I understand.
But we can close that day. If all information provided is satisfactory, we can close that day.
I thank you.
Okay.
Okay.
Thank you.
If you need any questions or clarification, please do reach out to, I think, Ms. Matias, you're handling it. Please reach out to Ms. Matias so that, whatever is submitted is absolutely.
Ms. Matias has been very helpful with her guidance on this matter.
Yes, we know that.
Thank you.
Okay, thank you very much.
Okay, thank you.
Thank you.
Okay, next item is item number 32, 2023-09A, 43 Cunard Avenue, Staten Island. The lineup is.
Hi, Elise. I should have James Morion, but I'm gonna text everyone. All right. I wasn't sure how long the one before us would take. But I can try to answer some of the questions in the meantime. We also, I see DCI John Daly is on, and he might have to speak on some of the issues you brought up. But we're trying to get an engineer who created the BPP to get on the call in as well. So I can just swear me in right now and maybe.
No, it's an appeals case and
Oh, then I don't need to be sworn in. Sorry. So I'll just go through the comments I can go through. And the architect and the engineer hopefully will come on if you. Okay. So in terms of the zoning analysis form, I heard the back and forth. We can look through the statement of facts, leave it as is because it is the full zoning lot, and we can try to clarify our specific lot more thoroughly in the statement of facts, if that's what you're looking for.
Yeah, I think so. Yeah.
Okay, cool. The builder's pavement plan with the street trees on the sidewalk, they're happy to amend. It isn't a, we'd like to point out it is an approved BPP, but it can be amended to put the street trees if that is what you
That would be great.
Okay.
I don't think that's too difficult, is it?
I'm hoping that the engineer or the architect can come on and tell you, because as you may know, I don't file for those things, so I want to tell you how difficult it is, so I don't know. But they told me they could do it, so doesn't sound crazy.
All right, that's then the answer is it's doable.
Does it require city planning certification? No, because we're not touching the steep slope and everything's as of right. So we meet all DOB requirements, so we're not required to go to city planning for a certification.
Even though it's in the Hillside Special District?
Yeah, but we're not, it's about touching the
Yeah,
Because that's a steep area.
right. So you're staying away from that steep portion of the hill.
Mhm, and you should be able to see that on the survey and the plans.
Okay, yes.
We can add
So you can just, in your cover letter, when you write the response, you can just put that as your answer to.
Okay, no problem, sounds good. We can definitely add a statement that, about not being a self-created hardship, and that, you know, it's very minimal ask. That's easy to add. So. Okay, and then, in terms of the questions with the fire department, should the fire department speak first, or do you want to hear my answers first, or I don't know, because.
Why don't you respond typically?
Okay.
The fire department afterwards.
So I was told that what's required is we need a 30 by 30 area in front of our lot, and that's what we're given. And that's how we meet the code requirements, is we have the 30 by 30 area on our lot. And we do have an approved BPP, which I was told we needed some sort of fire department approval to obtain. I was hoping somebody could come on and speak to that a little more, but that is the information I have about that.
Is one of your colleagues of last digits 451 and the telephone number?
Let me check.
There's a phone number in here.
Yes, 411. Oh, there's a 4115. Is that what you just said?
No, 451. If the person calling on 451 is party.
Oh, yeah, 8451, yeah.
Yeah, Cunard, please join us. Please unmute and join us. Thank you. And identify yourself for the record.
Hi, this is James Morey, the architect. Can you guys hear me?
Yep.
Yes.
Thank you.
Okay, I'm on. Thank you.
Okay.
This is
And, yeah.
Deputy Chief Inspector John Daly. I heard your conversation. I do need a few minutes to pull out the plans. So if you can just give me a few minutes, I'll get back to you to answer your question regarding the frontage space for 30 by 30.
Okay, no problem.
Thank you.
Go ahead, Ms. Fuller.
I'm gonna see, I thought that Commissioner Shetta's question and then your question were both about fire department access and the BPP, so.
Yeah.
I don't.
The other question I had was when I was looking at the BPP, the street width was shown as 20.
Yeah, but I think that connected to that.
Okay, that's the larger connect, okay.
So I don't, have more to say about it, unless, Jim, you can add to how it complies with fire department. But we might need Mike for that, I don't know.
I could speak to that a little bit.
Get your name for the record.
My name is James Morey. I'm the architect of record, 43 Cunard.
Okay, go ahead, Mr. Morey.
Yeah, so speaking to the fire department approval, the width of the road, I would only just say that typically for one house, as long as you have a 30 by 30 frontage space, which we do provide, the fire department usually approves a street width less than 30 feet. And just also added to that, the fact that Cunard Avenue from its nearest intersection is only 20 feet wide. I would assume that widening the road at the very last portion for a small stretch probably wouldn't make any sense, because the fire department only has 20 feet of access anyway to get up to that location. Typically, I think that 30 feet is reserved for a development where you have multiple homes, where you would need some sort of
Then I think your statement of facts or the BPP somewhere, the document needs to clarify that. And I think that for that, we need the fire department's okay on all of this. Because while you're citing the fire code and the code says 30 foot, it's not very clear how that is translating to the site and therefore meeting and is meeting the fire code requirement the way it's written. So I'm not an expert on fire code, so that's why we need to look at we need fire department to let us know whether what's proposed it meets the requirements. And since it's approved, I'm assuming it.
Okay, Madam Chair, I was able to find the application. I have the plans in front of me, and I see they showed a 30 by 30 frontage space, but as drawn, I know city planning and the Bureau of Operations would not accept this. One, that we have to drive over a curb and to do staging. This is something they would require a variance from our city planning unit in the fire department. And I will be back in the office on Wednesday, and I can speak with Captain Malloy of the city planning unit and get a quick answer and send an email to Elise and to the project manager, the BSA project manager, to let him know the definitive answer to that question.
And the engineer from the BPP says he is on, so if you need to speak to him in any regard, he is here.
That's the person with the 115?
Yes.
Yes, if you can join us, sir, and state your name for the record.
Sorry to do this.
That's okay, as long as we get our answers.
Hi, it's Michael Schaefer from Island Engineering Associates.
Go ahead.
So did you hear the fire department's comment just now about potentially needing a variance?
I caught the last couple of seconds of it. I'm sorry, I'm driving. I'm a little unprepared. They're objecting to the 20-foot wide existing roadway. Can you fill me in?
We are objecting to we see here a 30 by 30 area, but for us to get to that area, we'd have to drive over a curb, then onto the lot to start staging. And our trucks, we cannot go over curbs.
Well, if we're discussing the 30 by 30 area, I think that's more of a question for the architect. Fire department compliance would be under him. I filed the builder's pavement plan, so the roadway curb to curb width would be more my discipline in this application. So I was under the impression that we were looking for a 30-foot wide roadway paved, correct?
No. I mean, I understand that the 20-foot wide roadway is established by the city, and of course to widen it, it's next to impossible. I don't know who owned the adjacent property and so on and so forth, but the location and the arrangement for your 30 by 30 frontage space is what we object to.
So the 30 by 30 frontage space is taken from the city record line going into the property, if I'm not mistaken, correct?
Right, but for our apparatus to have to go over a curb, then the sidewalk, and I'm hoping that that area is going to be all asphalt or concrete.
It will be all concrete. The curb and the sidewalk are contiguous, so it's a totally hard surface.
That's a drive.
There,
So operations wise, there's also a double wide driveway that's being shared with the adjacent property. So there's going to be roughly 18 to 20 feet leading from the paved roadway in Cunard Place back to the front of the buildings,
Need an easement agreement on that?
which would provide access to the 30 by 30 space. I think it's the way it's been done on a few other projects, which is why they tried to recreate it.
Right, no.
I
Yeah, we would object to that because, for example, if you, next door neighbor, they park their car right on the lot line, say, and then, for us to maneuver our apparatus into that between the curb and the lot line there, it's pretty narrow, and the width of that sidewalk is what? I can't really see it. But no, this is something I would definitely have to discuss with our Bureau of Operations. And like I said, I'll be there back at headquarters on Wednesday, and I can send Elise and the BSA project manager a definitive answer if a variance is required, or if the Bureau of Operations would accept this 30 by 30.
All right, you know what I would suggest? This is getting, this is something that Ms. Fuller, I would suggest your team and Chief Daly discuss it and have it reviewed, because until we have the fire department sign off on it, we cannot proceed.
Understood.
And another thing that was mentioned, it seems there's another shared driveway. If there's a shared driveway that further provides the access way, and that is being considered as another way to provide access for fire department, then you need to have an easement agreement with that shared driveway. So as you're formulating the concept, please back it up with all the necessary legal documents to ensure the feasibility of it.
Okay, understood. So I guess we will await FDNY opinion, and then we will respond accordingly.
Right. And so my question for Chief Daly is, how long do you think it will take for your team to get back to?
I'll have an answer on Wednesday. If I have no objection, I can prepare the letter immediately. If they do object to it, then they would have to file an application, and that could take 4 to 6 weeks for review.
Okay.
Madam Chair, am I allowed to say something?
Yes, Ms. Matias.
Okay, just a point of caution, Ms. Fuller, I believe, and I was just looking for it. We had prior Cunard Avenue cases within that, and I believe 43 might have been one. There was another one that had 3 lots, which was a Rothschild case. So I'm going to research that and get to you. They were withdrawn.
The Rothschild case was not on our lots. It was
further down.
Further down, yeah, it was on the same block.
Area. This is a steep area, and I remember doing a site visit.
Yeah, but we're not using that steep section.
Yeah. So I think there were issues that were raised. Excuse me, let me finish. There were issues that were raised with accessibility. So I'm going to check that and get you that information.
Thank you.
So that maybe there was some information that could help you and the fire department or something. Okay.
Okay. I just wanted to also add though that the other Cunard case that was I'm blanking on his name right now. That was the same lot as our lot, but it was totally reconfigured in a new way now.
Okay. Okay. It just it rings the bell, and I know there was a lot of issues at that point in time with the former borough president that we visited at the site.
Yes, I remember that site visit.
Yeah.
Yes.
So.
For the record, I believe that was a private driveway serving those houses. They weren't accessed from the public roadway.
Okay.
If I recall the site correctly.
All right.
That may be what you're speaking on as far as major issues go, because I would agree with you. The steepness of the site itself and the accessibility from a private road would have made it very difficult.
Okay.
Yeah, that was a private road.
It was a private.
That was a private road. Yeah.
Okay. That just.
But it was all very hilly and steep hill and there were, I remember.
Right, right.
I'm sure Tony will get to the bottom of it.
Okay, all right. So I think a lot of it is dependent on fire department's review. And so we definitely cannot schedule it. I think August is possibility, assuming you can get all your responses in. Not in September.
I think that once you see whatever happens on Wednesday,
We'll set the date accordingly.
yeah.
Okay. Hold on, why is that noise coming? Okay, Commissioner Shetta.
Thank you. Regarding the disturbance for this discussion, I'm confused about, are we talking about we're not disturbing steep slopes where the building is, but there are steep slopes somewhere else on the side?
So basically, the Hillside Preservation District is very clear about how much of the steep surface is being eroded. And so if you do erode beyond a certain amount, it requires a certification from the Department of City Planning. So in this case, the applicant has picked the least steep portion of the site to position the building. And because of that, applicant is stating it therefore is as of right and does not require a city planning certification. Had it been, let's say, further down the hill where you're cutting into the hill. If you look at,
Is there a limit on the steepness?
I don't remember the zoning district regulation.
And can the applicant clarify about that in the
But-
submission?
But because you want to make sure that this is not
Steep is not a criteria. Steep, if someone could look at 1-on-2 slope and believe that's gentle. Somebody else could look at 1-on-10 slope and believes that's steep. It depends. So it should be a criteria. If the slope disturbance is steeper than such, that's considered a disturbance of steep slope.
I understand what you're saying.
That's what I want them to clarify.
I mean, that should not be an issue, but
Yep.
I think we are not waiving any of the regulations of the underlying zoning anyway. So if DOB determines that this is a steep slope, they have to go back to city planning.
Okay.
Anyway,
fair enough.
but just to make your life easier, Ms. Fuller, you may just want to cite the zoning resolution section, which
Okay.
refers to the steepness and how this site therefore meets the requirement and thus not require a certification.
Okay, no problem.
Yeah, I forget. I remember I did a case on a hillside preservation, but I forget the case. I forget the percentage.
The contours, the reason I mentioned is look at the contours on the plan.
Yeah.
At the very bottom of the site here. Yes, the contours are kind of close. This is where the slope is kind of steeper than the other.
Let's not speculate.
okay.
Let's not speculate. Let's just let Ms. Fuller there. I can easily look at the zoning resolution, but it will take some time.
Okay.
It's been a while for me when I've looked at this special district. So, okay.
All right, you want to go to the public?
Yes, let's go to the public.
The case that we're currently discussing is 2023-09A, 43 Cunard Avenue, Staten Island. Should you wish to discuss, dial 646-558-8656 or 888-475-4499, which is a toll-free number. At the prompt, you will enter the webinar ID number 816-3044-2359 and press the pound sign. At the next prompt, you will press the pound sign only. Once you're in, press *9 to raise your hand, press *6, or press *6 to unmute to be able to speak on the phone. And if you're in the Zoom room already and wish to discuss this matter, please raise your Zoom hand, which is a small hand at the bottom of your screen. Once you're permitted in, you will have 3 minutes in which to discuss.
%25% or greater.
The slope.
Average percentage, yeah. That's what I'm quickly just.
25%.
Can 115 number mute because it's interrupting the.
Pardon?
Excuse me?
There's someone on the phone.
Okay.
Okay, it's muted now. It was just interrupting.
Yeah, anything greater, equal to or greater than 25%.
25% or?
Yeah. 25% one can use the map with a 2-foot contour intervals and a scale of 1 inch equals to 20 feet, such as the map picture, at 25% slope on a map of 2-foot contour interval is indicated by contour lines, which is 8 foot apart, rounded by. Oh God, I can't believe it. I went through these calculations at one point in my life. Identify where the contour line is. Okay. So it gives you a complete analysis, and based on that. So it's definitely where the site is located, it's less than 25%. At least visually, I'm just looking at it.
Okay.
But
And since we're not waiving it,
no, we're not waiving any.
okay.
Okay,
Okay.
so no one's called in? Okay, so how much time do you need?
Okay, how much time do you need? Oh yeah, we discussed it. It all depends on
Fire
fire
department.
department's review. And so please coordinate with our
Jillian.
I think Jeline, and then we'll identify a date for the next hearing.
Okay, no problem. I think on Wednesday I'll give her a call.
Okay.
So go back to the.
Yes.
Yeah, okay.
Thank you.
Thank
Thank you,
you.
Ms. Fullader. Thank you, everybody. And good to see you, Mr. Chief Daly.
Okay, we are recalling item number 31993BZ. Here's mine.
Do we have to open it?
Yes, we do. Please join us, Mr. Consagrea. Okay, let me go back and reopen this case.
Okay, I'm here.
Okay, just give me 1 second to reopen this, and then I will swear you in, sir. Okay, we're going to motion to reopen.
Yes, motion to reopen.
Chair Shanda.
Aye.
Vice Chair Shabeta.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Yoon.
Aye.
Okay, Mr. Consagrea, raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond on each of board member questions?
I do.
Okay.
Go ahead, it's yours.
Okay. Yes, thank you for giving me the opportunity to speak to the board. I assume by the lack of communication with someone else that my client is not on. I was able to speak to him about an hour ago, and he said he would be on. He would be calling. I gave him all the information that he's had. But anyhow, yes, I did get a chance to listen to the review session from this morning, and I understand the frustration behind, rightfully so, all of the commissioners. My client has attempted since the last meeting to do a lot of the due diligence and work that was requested of him. I know that he's gone to great lengths to put in planters on one side of the building or put in actual trees on the side of the building. He's erected planters. He actually had a visit on June 2nd from Ted Ricketts, the compliance officer from the Board of Standards and Appeals, who told him that, he had seen that he had done a lot of work. And my client, Mr. Majed Al-Jamal, had done a lot of work. And so my client, and obviously I won't go into reasons. One, they sound like an excuse, and two, they're of a personal nature, which I don't want to share during a session like this. But I have been unable to communicate as much with Mr. Jamal as I would have wanted to, but I had the expectation that he's been doing everything that he needed to, or at the minimum, working with Mr. Binroy Bell to figure out all the things that he needed to get done to be in compliance or to gain the approval from the board. And so my client has sent me a lot of pictures, which I have forwarded, and I had asked him to forward to the board showing all of the various changes, the changes to the building, the removal of signage, the removal of lights that don't work anymore on the corner, the peak of the triangle of the property, the striping, the cleaning up of the side, the putting away. He took a video putting away the trash can every day in his building as was directed. And so all of those things that are the most visually impactful to the community, to the neighborhood, he has done. And I, would have wanted to have had more communication with him to, make sure that he would attend this session. And I'm not sure the disconnect between, understanding that he needs to not only do the work that was requested of him in terms of all of the cleanup of the site and compliance with lighting, compliance with signage, but also to attend these meetings. He did attend the last meeting, and he, agreed to do a lot of the things that were, or to do all the things that were asked of him. I know that he has not yet done the bollards on the property, which he still contends that is makes the whole process difficult of parking cars on the property in terms of when they're out. He's saying that he's complying by keeping the cars within the striped areas and not having too many cars. And so that is the latest I have here. I wish he would join us on this call because then he would be able to explain in more detail than I, speaking from 2,000 miles away.
Okay, well, I would tell you one thing. When you submit these drawings or photos before you submit them, please look through them, because what has been submitted basically shows why we definitely need the bollard. Because what we are seeing is that, yes, the space has been striped, but that still is not stopping your client from parking on the sidewalk. Okay, and there are not just one, several vehicles on those photos indicate that vehicles are being parked on the sidewalk. So it definitely is not consistent with what you are saying or what you are being told, or with what we are seeing and what you are seeing on the photos if you look carefully. So and therefore at the last hearing, we agreed to a bollard, and there was a concern that was raised about vehicles coming in and out. And we said, okay, it will be only up to the point where the vehicle entrance is. You don't need the sidewalk for the rest of it. Where you have the two curb cuts, one on Eastchester and the other one on, I think, 251, whatever that street is, you have those two curb cuts, and you need the vehicles to enter through those curb cuts. There's no need for the vehicles then get onto the sidewalk and then go wherever they want to. Sidewalks are not meant for vehicles. So there is a reason why the bollards are being asked to be placed exactly at the location where the sidewalk doesn't need to access the building, need to access the site. I think we were very clear about that. If you needed clarity, you could have asked our project manager for up to what location that was being asked of. And that's exactly when I think also as part of that discussion, you yourself volunteered to do a topographic, to do a survey to determine the meets and bounds of the property before you would install the bollards. That has not been provided. And painting of the striping of the vehicle, I think parking space, I think that was done as part of our prior hearing. It wasn't done as part of this recent hearing. I think the striping was done before that, if I seem to recall. Yes, Commissioner Otley-Brown.
I also want to take issue with the way in which you're submitting things at the last minute in response to us commenting in public. The proper submission date is 20 days before the hearing.
Yeah.
That means we need everything that responds to all of our comments in the previous hearing submitted by that 20-day before the next hearing date. And it needs to be accompanied by a cover letter that details what you are submitting and what each submission is responding to. It shouldn't be that we keep requesting the submission, and we don't get any response whatsoever, and our project managers get no responses whatsoever, and on the day of the hearing, a few photos get sent in an email, and we have to figure out what are these photos responding to? And then, of course, looking at the photos, determining it isn't the kind of response we're looking for. It shouldn't be like that. And it isn't like that for any other case. This is the case that we're having problems with.
Madam Chair.
And
Council.
ordinarily, we would
Take
be
care of one thing.
forcing an adjournment on an applicant that behaves in this fashion. But because of the repeated history of non-compliance with this property, we feel we need to make an exception to our rule of automatically adjourning, because we're worried about not having the constant connection with you and your applicant to impress upon you how important it is to operate within the geographic bounds of your site and to not be a nuisance to the community. And the nuisance to the community has been documented several times by the community board, by the council member, by commissioners on this board who have done site visits, by our site compliance officer over and over again.
Consistently, unfortunately.
I just want to follow up. Mr. Bell is the case project manager on this matter. It was represented that that you were speaking directly with the owner of this premises and trying to work alongside him. Have you ever spoken to the owner?
I never spoke.
Can you speak into the microphone?
Oh, sorry.
That's
I never had any conversation with the owner.
Did the owner reach out to you?
No.
No. Okay.
So, Mr. Consuelo, you stated earlier that the case planner was working with the owner. Is there anything you want to say to that?
No, I mean, I was at the last hearing and I heard that the caseworker would be working with the owner, was encouraged to, and I, left it up to my client. That's,
Let me
his
just make it very
responsibility.
Let's make it very simple. The role of the project manager is to provide guidance as and when requested, and to remind the applicants of the due dates and the submissions, and if any further clarification that is needed, to provide that. We went out of our way to reach out to you and not the other way around, to make sure that you knew what our process was and what the submission requirements were and what needed to be submitted. That was done initially. And subsequent to that, it was up to you. We've assumed that you knew the system and the process, and it was your responsibility as a representative to your client to reach out to us and ask for clarification if you think you needed it. Not only did you not do that, you left it to now you're stating you left it to your property owner to reach out to our project manager, and you made these assumptions and you're making these statements. I think that is a very false representation, not just on behalf of your client, but also on my project manager. That's not.
Chair, I'd just like to add for the edification of the record that it is never, not in this case and not in any application, the duty or responsibility of a BSA project manager to prosecute an application of a private landowner, a represented individual.
We have Mr. Rickards here. He is our compliance officer. Mr. Rickards, did you make any representations you went to a site visit on the site?
I have. I went to the site, I believe, at least 3 times at this point in the hearing process.
And any of those times, have you ever made any representation to the quality of what work was done?
I did not. I did identify to the site manager or operator of the auto repair that I did observe he had done striping. He had removed some signage, and he had moved those cars that were outside of the lot line on the sidewalk to within his property lot line. That was all that it was acknowledged at the time of the site visits.
Thank you, Mr.
Thank you. All right.
I just think, Mr. Consuegra, I think that you're failing to represent your property owner here. And I think that by kind of throwing him under the bus here makes you look like a bad representative for your client. And I think we're frustrated that it sounds like based on your testimony that the applicant is actually working to fix some of these things that we've asked him to, but that you are failing to represent that to us. And I believe that that's your job in this relationship. Yes?
Very well put. Yes. And it should not be up to us to go and make those site visits and check whether those are being done. You are keeping track of all the questions and comments that are being raised. And it's for you to follow up with your client to make sure if those things have been responded to or not. And when are the due dates and when are the deliverables, and then coordinate with your team. Your team include, you're the coordinator of all the work that is going on. I'm not sure why I'm explaining this. All right. Do we want to open it to the public? Yes. Let's, since we have reopened it, we might as well open it to the public. Yes.
The case we're currently discussing is 319-53BZ, 1135 East 222nd Street, the Bronx. Should you wish to discuss, dial 646-558-8656 or the toll-free number, which is 888-475-4499. You will enter the webinar ID number 816-3044-2359 and press the pound sign. At the next prompt, you'll press the pound sign only. Once you're in, you'll press *9 to raise your hand, *6 to unmute if you're calling in on the phone to be able to speak. And if you're in the Zoom room already, please raise your Zoom hand and Zoom hand, which is a small hand at the bottom of your computer screen. Once you are acknowledged, you will have 3 minutes in which to discuss. There is a phone number that ends in 996. Will that person like to join us, please? Just in case, I don't know who that is. And then I know that the community board manager is here also.
Good afternoon.
Want to let Mr. Torres speak?
Good afternoon.
Yes, district manager.
Okay.
Hi, this is Majed Al Jamal.
Oh, the owner? Wait, Mr. Torres, can we hold you up for a second?
I'm here, but if you want to have, I'll wait.
Yeah, unfortunately, we need to speak to the property owner. He's part of the applicant team.
No, that's perfectly fine. I'm curious to hear what he has to say as well.
Thank you, appreciate it.
Sorry. Mr. Jamal, please continue to speak.
Yes.
Sworn in, Ms. Matias.
Oh, yes, I apologize.
I'm
Yeah.
sorry.
I'm sorry, thank you.
Yeah, we need to swear you in, Mr.
Sorry, I have to
Jamal.
swear you in. Thank you, counsel.
Yeah, Ms. Matias, is your microphone muted?
Oh.
Oh, it's turned away.
Oh, sorry, it's turned away. I apologize.
Thank you.
Okay.
No, but I heard you. I heard you. Whenever you're ready, take your time. Take your
Mr.
time.
Jamal?
No rush.
Okay, thank you.
Yes, good afternoon.
Thank you, sir. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board to respond honestly to board member questions?
Yes.
Okay. Do you want to respond to the commissioners?
I just got on like about 5 minutes ago, so if you could address me with a question directly, it'll be better because I don't want to assume anything or make statements or something that I'm sure if I heard or I didn't hear.
Okay, Mr. Jamal, a question that we have is, how much improvements what improvements have you made to the site since we had the last hearings?
Perfect. Perfect question. No problem. I was asked to put the lines to address the parking lot issue so the cars don't lay over or don't go on the sidewalk or whatever. That issue was addressed. I was asked to get the garbage can inside the property, which I told them we'll do. We bought it inside the property. We painted all the white in the building, all the poles. We removed a lot of the extra signage that was there. And the only thing that they were waiting for last time was two things. They call that the survey, which we got. And they asked us for the survey. That's something that we didn't have at the last phone call, but we got that now. There was a delay. I don't know why, but We had paid for it right away to hire them right away. There was a delay, but they finally gave it to us. So that's out of the way. So from the things that they asked me for, just clean up the stuff, move the debris that was outside, all the weeds, everything is cleaned up. And I added 3 trees on the right side of the property. And like I said, with the left side where the garbage can was, they said not to do anything until we confirm what we're gonna do there exactly. But the right side, we already planted the 3 trees, and they're exactly what we said, the evergreens. So that's all taken care of.
So,
And no cars on the sidewalk.
okay, so let's take one step at a time. Each time you make these improvements, take photos of
Yes.
the improvements. Okay?
Okay, of
And-
course, no problem.
And send that to Mr. Consuegra, and he will be submitting
Okay.
the documents to us, proving that you have done these improvements. With regards to
Of
the
course.
survey, please send us a copy of the survey. And what does the survey show? Does it show that the sidewalk belongs to you?
Most of it, no. Most of it belongs to the city. That's what I was told by my representative. But I believe, if Mr. Contreras is on the phone, I believe that she already provided him with a copy, or the survey
No,
company
we
did,
have
so you
not.
can ask him.
And Mr. Jamal, this is where I think we need to be very clear. We have not received anything since our last hearing. The only thing that we received today, while we were in hearing at 10:30 a.m., few photos, and those photos still show that there are vehicles that are parked on the sidewalk.
Right. And last time we spoke, I was on the phone, I was told that somebody will reach out to me or whatever. But like I said, I'm a type of guy that I'm on top of everything. So if you want to give me somebody's name, number, whatever you need done, I'm more than willing to do it, because I would love to resolve this issue. I'm
Okay.
not delinquent. I'm not a delinquent person. I like to stay on top of everything, but
Thank you.
Mr. Jamal?
I'm going to state for the record that you
Yes.
are represented by counsel in this matter. That is the person who you will be calling and speaking to for advice on how to proceed and prosecute your application.
I'm sorry, you came like a little bit in and out. Could you please
Can you
repeat what you
repeat
were saying?
yourself, General Counsel?
You are represented by William Consuegra for this matter. That is the
Okay.
individual to whom you will be speaking with regarding how you will move forward with this application.
And like I said, whenever I planted the trees, the pictures were sent. When I painted the sign, the pictures were sent. So that's what I'm saying. So I don't know where we at now, but like I said, if you want us to resend it to him and whatever, but whatever you want, I'd be more than glad to do it. We have no problem doing that.
All right. So I think there's a lot that you and Mr. Consuegra need to talk it out and figure out who needs to do what and who needs to submit what. We cannot be, and all we can tell you from our files, we haven't received anything other than those photos, which I'm happy to hear that you were contacted by Mr. Consuegra, because we were told otherwise today, and you provided those photos immediately, but those photos are incorrect. They still show vehicles parked on the sidewalk. So you need to stay on top of it even more so, and tell your employees, that they cannot do that. And anybody who parks their vehicles on the sidewalk, their vehicles are going to be towed. So that is one of the reasons why we asked for those bollards to be placed. And now that you have the
Okay, but yes. I looked at the pictures, and like I said, can you specifically tell me a picture of the 2 or 3 cars that are in the picture, so we can address it right now? Because I'm looking right at the photos. So
Sure.
you can tell me, because I don't see anything on the sidewalk right now.
And the reason I think this confusion is happening, you yourself don't know where the edge of your boundary is. And that's why the bollards will make it very clear to you as to where your property boundary is. And therefore you will know when a car is parked outside of your property boundary. That's true. And I'm trying to locate the photo. Does anybody have it? We can show it on the screen that way, Mr.
Yeah, because all the cars on the blacktop, there's one car that's overlaying a little bit, which is the white Audi, if I'm not mistaken. The white car with the hood a little open, the Audi. Is that depending, what side you're talking about? Are we talking the left side or the right side?
Here, I've got it. I will share my.
You have them, that I
It's
sent?
on the right-hand side. It's on the Eastchester side.
The one I showed you this morning?
Yeah.
Yeah.
Okay, so the white car is
Yes.
overlaying, is that the one?
Yeah. Right.
Yeah, so we can remove that spot, but that's the way they told us that it was supposed to be done. So we removed that line.
Who tells you that? Nobody can tell you that because that's that nobody can. Who will park there? Somebody else other than your clients?
I'm sorry, say that again?
Who parked that? Either your employees did, or if someone else without knowing parked it, it's your responsibility to tow that vehicle away.
No, but that's what I'm saying. Is that the one with the issue, that one car? That's what I'm saying. I could remove those lines. That's what I'm trying to ask you.
It's
Is
not-
that the side?
Okay. All right, this is the part I think Mr. Consuegra, you need to explain to your client as to what he has within his rights he can or cannot do. You need to put those bollards. Now that you have the survey, you have to put the bollards up so that the boundaries of this park, of this site is absolutely clear to Mr. Jamal and to his employees, so that they know exactly within which space those parking can be parked. It seems the striping is not doing anybody anything because you're still repeating the same mistake. The sidewalk does not belong to you, Mr. Jamal. You only can use the sidewalk to get from the street into your property. That's it.
Well, we understand that, but that where that car is tipping off right there, that's a very wide sidewalk over there. That's what
That
I'm
is
saying.
not the
Maybe you.
point. Mr. Jamal, you're missing the point. It does not matter if the sidewalk is 100 feet wide. You're not allowed to park any vehicle on that sidewalk. It's a city sidewalk.
I would advise the board to instruct the representative to have a call with the owner. There have been 2 substantive hearings on this matter, one in January, one in April. This was 3rd call today because the representative was not prepared either in submission or present at the hearing during the calendar call. This was the 3rd call today. I would ask that the board close the record, and if the applicant cannot review the videos, the review sessions and public hearings from today and the last 2 substantive hearings and make a fully responsive submission, then the applicant and the owner are at risk of being denied for failure to prosecute this application. I don't think the board should discuss this anymore, and I think we should go to Mr. Torres to allow him how he has patiently waited all day to testify to speak now.
I agree.
Well, let me just say.
Yeah, go ahead.
Thank you, counsel. I just do want to say, Mr. Jamal, this is serious. There's no parking. If things do not change on this site, and if we don't take the comments of this board, and they're all recorded, so you could listen to them online, but if you don't take these comments seriously, there's a very strong possibility that your variance is going to be denied.
And like I said, I'm not delinquent. I'm not looking to be delinquent. I'm trying to look like right now. Give me somebody that, listen, by Monday morning that I'm going to look at the survey, everything, whatever spot needs to be removed, I will remove it, paint it yellow so nobody parks there. I will handle it.
Jamal,
But I have no.
Mr. Jamal, I'm going to mute you. Ms. Matias, please call the public.
Now, Mr. Consuegra, you know this record doesn't look great, right? You can acknowledge this is not a great record for you. Or do you think you're able to? Do you think you're able to properly prosecute this case and to guide Mr. Consuegra into getting this matter resolved?
Mr. Jamal.
To Mr. Jamal, getting this matter.
Mr. Jamal. Yes, but my question is a question that came up, I believe not this last hearing, but the one before. The question of the width of the sidewalk, the general counsel said that there were no records showing the deed establishing the width of the sidewalk. So there's that question on the city side. The architect has been exploring that and can't find any records. What is the best way? Because that is the crux of the question. As you saw in that picture, there's a telephone pole that visually creates kind of a separation between the sidewalk and the owner's property. What is the best way to find out the actual size of the property if the city itself, doesn't?
I'd like to, so first of all, there was an allegation that I made a representation. I never said anything about the sidewalk width here. So I am the general counsel. I never made a statement about the width of the sidewalk. And this isn't legal advice. This is just common sense, a survey and meets and bounds on the deed. And as the chair stated, just operate from the assumption that you do not own a New York City sidewalk. It is not part of your property.
Okay, I think we should move to the.
Yes,
I think it's now time for Mr. Torres. To
yes, yes, Mr. Torres has been very patient. Thank you. Please go ahead.
No, I just want to say thank you. I've been listening all day long. The only thing that I'll say is I've been here for 7 years. I don't know Mr. Jamal. And this has been a property that has presented plenty of problems for us. I noted in the letter that we wrote that there were over 420 311 complaints, mostly noise complaints that were referred to the NYPD. In my district, we have the NCO program, which is a sort of program that you have a specific officer and they go and they deal with it. And I recall dealing with officer, he's now a detective, Benito Cruz, who was the section chief for that area, and going to this place to deal with many of the complaints that were going to the NYPD. And, you know, Mr. Jamal's assertion that he's a guy who's on top of this and dealing with these on a daily basis doesn't hold true in just the comments that we've witnessed and heard here. Like I said, I've been here for 7 years. We've made plenty of efforts for outreach. He's never attended any of our community board meetings that we had. We had 3 different meetings, 2 of which were missed by Mr. Consuegra. And now, you know, we're here. So I don't want to belabor it. The frustration in your voices, I can hear it and I understand. The community board voted not to recommend the extension because, quite frankly, 10 years is a long time. So even if you say yes today, or, you know, he comes back a year from now and says, I got everything straight, I have no confidence going forward that he's going to be able to hold true to his word, because he hasn't demonstrated that. In the 7 years that I've been here, that I've known, and the complaints from 301 date back to 2020. So that's 13 years of complaints. That, you know, there has been no complaints. Now, I don't know if he's held this property for that long, but like I said, for the 7 years that I've been here, there's been absolutely no desire to reach out to the community and deal with these issues. That's it. Thank you.
Thank you, Mr. Torres. Okay, are there anybody from public who wants to speak? Do we have anyone else?
No.
Okay, all right, then I make a motion to close.
Excuse me. Chair Shonda,
Aye.
Vice Chair Shabeta,
Aye,
Commissioner Otley Brown,
Aye.
Commissioner Sheta.
he had stepped down.
Yeah,
Oh, I'm sorry. Commissioner Yoon.
Aye.
All right, the record will stay open. So if Mr. Jamal and Mr. Consuegra want to submit all the improvements that's been made, documented, please provide that. With that, the survey, which indicates the meets and bounds of the property, and with that, provide the location, install the bollards. If you want this application to be approved by this board, if not, it's your call. Okay. All right. Thank you all for your patience, and I appreciate everybody's participation. And specifically, Mr. Rickett, it's rare we see Mr. Rickett join our hearing, but appreciate it. And Mr. Bell, thank you.
Okay, being that there are no other cases to be heard, this concludes the public hearing for July 10th, 2023.
Thank you, everybody.
Thank you.